February 27 meeting of the General Laws and Technology is called to order. Would you open the board so we can make sure we got a quorum?
Mr. Chair, you have a quorum.
All right, we got a quorum. All right, we got, this is presumably our last meeting of the year, so we will try to get, and actually we have a lighter docket this time than we've had the last few weeks, so we should be able to move along pretty well on things. First up is Delegate Tran.
Thank you so much, Mr. Chair and members of the committee. I have two bills. Do you have a preference?
Nope.
All right, can we start with House
You can
Bill?
pick either one, and we'll pass that one and defeat the other one, but,
I hope the threshold is not one, but I have House Bill 1221.
all right. House Bill 1221.
So just so you know, this issue was highlighted for me by a constituent whose son opened a car shop in Stafford. It has since grown, and he's had to move, and it's really exciting for him and exciting for an example of a good small business that's growing in Virginia. However, he had a lot of trouble finding information about, once he got his business license, what to do next. Whether it was the taxes he owed, the insurance he needed to have. For example, he didn't realize he had to buy, workman's compensation, documents he had to submit, what the labor laws in the state were, et cetera, et cetera. So we did some digging, and if you look at this information, it's scattered across the Virginia state government. It's not really located in one site, which makes it really tough for our small business owners as they're getting off the ground to figure out how to really sustain and grow their businesses in meeting Virginia's regulatory requirements. This bill would require the Virginia Department of Small Business and Supplier Diversity, in coordination with the state's regulatory agencies, to develop and provide guidance to our newly approved small business permit holders. And so this information, for example, they're working really hard right now to update their website. We want to make sure that we're codifying those efforts, and without such, it might end up going away again. So I would welcome your questions.
All right, are there questions of the patron?
Mr. Chair.
Yes, Senator
Delegate
Reeves.
Tran, are you talking about Business One Stop, the website that has all that stuff? Are you familiar with that?
Let me just see. We were looking, I don't believe that we were looking there, and the department didn't point me in that direction.
Mr. Chair, I'd just
Senator
comment to Delegate Tran, if you look at businessonestop.virginia.gov, it does encompass a lot of what your bill is trying to do, I believe.
Okay, I'm just pulling it up really quickly. Oh, Senator Reeves, that has not come up throughout this whole process.
Mr. Chairman,
Yes, Senator Bell.
I think to help answer this question, if I'm looking at fiscal impact statement, it actually says that the business one stop, it says Department of Small Business Supplier Diversity indicates it will be able to absorb any impacts and workloads, because as they are updating its business one stop system, it will incorporate her adjustments from the bill into that plan.
I'm sorry.
All right, thank you.
So I actually, what I think they're saying is you're good to go. It matches with business one stop.
It does, and I
folded
apologize.
into that.
This was during the summer, but yes,
All right,
codify that work.
any other questions of the patron? All right, is there anyone to speak in favor of the bill? Anyone to speak in opposition? All right, we have a motion and a second to report. Is there any further discussion among the committee? All right, we will go then to the vote. Cast your vote on the board.
Ayes 11, no 0.
All right, ayes 11, no 0, no abstentions. Bill is reported. Next.
House Bill
Julia.
1228, sir.
All right. Who's that?
House, we do have an amendment.
All right.
I think he embedded into a substitute. I apologize. We do have a substitute.
All right, we got an amendment in the nature of substitute. There's a motion to adopt the substitute. Is there a second on that? All right, we got a second on that. Any discussion or questions as it relates to the substitute? All right, all in favor of adopting the substitute, say aye. All opposed, no. All right, the substitute is before us. Present.
Mr. Chair, House Bill 1228 would require state contractors with contracts that are over $10,000 and more than 5 employees to provide sexual harassment training to their employees that are providing services in Virginia, and to post or make available their sexual harassment policy, as well as directs the Department of Human Resource Management to identify and develop procedures to determine whether an employee of a contractor with our government spends significant time working with or in close proximity to state employees, and if so, to offer the state's sexual harassment training to those employees, so like if you were a contractor on site. I think that the reason for this is just to make sure that our state dollars, our state taxpayer dollars, are going to work, businesses that are ensuring safety in terms of sexual harassment and sex discrimination in the workplace. And despite, advances in the conversations around sexual harassment continues to persist in our society. And according to the United States Equal Opportunity Commission, conservative estimates show that at least 1 in 4 women experience sexual harassment in the workplace, and that instances of sexual harassment in the workplace are significantly underreported if workers are unaware of their employees' policies and what actions actually constitute sexual harassment at work and how to report it.
All right, are there questions of the patron?
Mr. Chairman.
Senator Ruff.
How does the substitute differ from the original bill?
That's a good question, sir. The substitute differs, that we had a change where in the original bill, we said that the contractor had to offer the sexual harassment training within a calendar year of signing the contract. And what DHRM said in conversations with them was that sometimes that timing doesn't work out quite well, and so it changes it to within a year. So it gives them a little bit more flexibility. Counsel, sorry.
Okay. Mr. Chairman,
Yes,
I
Senator
would,
Ruff.
how much is this going to cost the department?
The FIS says that the department can absorb these, both identifying the procedures and offering the training.
To any unknown number of employers, they're going to be able to offer this for free?
I believe this is an online training, but that's what the FIS says, so I believed the FIS.
Okay. Thank you.
All right, any further questions of the patron? Yes.
I'm sorry, because I'm reading this substitute. Are we saying that the department is creating the training module and the businesses of 5 or more just use their training module? Or are you asking everybody to create the training module?
Thank you, Senator. Mr. Chair, I would respond to the senator by saying that the department's training module would be only offered to those contract employees who spend a significant time on site in a state agency. And that if you were a contractor who had employees who are not on site, then you would have to be offering that training yourself. And I would continue by saying, under the Virginia Human Rights Act, employers with 5 or more employees cannot have sex discrimination, which includes sexual harassment. So I would imagine that the vast majority of those employers are taking precautions to make sure that they are offering safe workplaces already.
All right, any further questions of the patron?
Mr. Chairman,
Yeah. All right,
Mr. Chairman,
yes, Senator Bell.
Mr. Chairman, just reading the FIS on this, it says Department of Labor and Industry indicates the bill will not impact the work of the agency, and they go on to say that the cost of developing required procedures and communications to all agencies is expected to be minimal, can be absorbed within their existing staff resources. So I'm ready to make a motion at the appropriate time.
We'll get the appropriate time in a minute. Is there anyone in the public who wishes to speak in favor of this bill? Anyone in opposition? All right, now would be the
Mr.
appropriate. Okay.
Just one follow-up. I want to make sure we're all clear.
Yes, ma'am.
Senator Donovan.
This is, because we're looking at a lot of these pieces of legislation, this is all for only contractors that contract with the state of Virginia with 5 or more employees who are on site. It is not for the private sector.
It is for all contractors who contract with the businesses who contract with the state of Virginia who have 5 or more employees and a contract that is $10,000 or more.
Correct, but not for the general public.
That's correct.
Okay. Thank you,
All right,
Mr.
thank you.
Chair.
Okay, Senator Bell? All right. Okay, we have a motion and a second to report. Is there any further discussion among the committee? All right, we will vote on the board, so.
Ayes 12, no zero, one abstention.
The bill is reported. Thank you very much.
Thank you so much. Appreciate your
Certainly.
time.
Delegate Hope.
Thank you, Mr. Chairman, members of the committee. I have House Bill 1078 before the committee, and I do have a line amendment.
All right, House Bill 1078, draw your attention to that. And do you have a line amendment to the council to report?
Thank you, Mr. Chair. So on line 19 of the engrossed bill, strike or professional engineering and insert, comma, professional engineering, comma, transportation construction, comma, or transportation-related construction.
All right. Everybody get that amendment? So it's basically architect. Yeah. All right, the amendment will, they basically talk about contracts for architectural, comma, professional engineering, transportation, and et cetera, et cetera. So they're talking about different types of services that would be provided here. All right, we have a motion to accept the line amendment. Is there a second? Second. All right, any discussion on that? All in favor say aye. Aye. All opposed, no. All right, the line amendment is adopted.
Thank you, Mr. Chairman.
Certainly.
Members of the committee, House Bill 1078, basically what it does is it would allow a locality when considering procurement bids to show preference to a firm that hires people with disabilities. The line amendment that you just approved had some exceptions attached to it. This was a real-life example that happened in Fairfax County. People with disabilities were employed by Fairfax, and they ended up losing their job because the job shifted from a nonprofit, which we allow, to a for-profit. And the constituent came to me that had their son that was employed doing some computer breakup type work, and they unfortunately had to lose their jobs. And so what this bill would do is it would say what I believe is already in the law implicitly. This would allow it to be explicit to say that it doesn't require the locality to do this, but it would allow them to show preference for when the firm hires people with disabilities. That's all the bill does.
All right, any questions?
Mr. Chairman.
Yes, Senator Ruff.
I didn't get the placement of those line items. Exactly how does that change what you're?
Mr. Chairman,
Certainly.
Senator Ruff, what it does is it would have some exclusions in there, and so for firms that hire engineering, transportation, construction, or transportation-related construction, the industry came to me and asked me if I would put in that amendment, and I'm fine with doing that. That's not an area where you would normally hire people with disabilities anyway, the group that I'm looking at, and so I'm comfortable with that amendment.
So it increases the number of types of services that are exempt from the bill.
Yes, Mr. Chairman.
All right. Any other questions anyone has here? So, all right. Is there anyone in the audience who wishes to speak in favor of the bill?
Mr. Chairman, Karen Tefelsky from Virginia Access, and we would appreciate your support. This helps leverage the procurement policy of the Commonwealth to help employ veterans with disabilities and other Virginians with disabilities.
Thank you. Anybody else speak in favor? Anybody in opposition to the bill? All right. We got a motion and a second to report. Any further discussion among the committee? All right. We will vote on the board.
Ayes 12, noes 1.
Ayes 12, noes 1, and no abstention. So that bill is reported. Thank you.
Thank you, Mr. Chairman.
All right, Delegate Watts.
Thank you very much, Mr. Chairman. I have a substitute for House Bill 1418.
Okay. 1418. All right, we have a substitute here. All right, we got a motion and a second to adopt the substitute. Any discussion on that? All in favor of adopting the substitute, say aye. Aye. All opposed, no. With the substitutes before us, and you can present your case now.
Thank you, Mr. Chairman. The bill before you is part of the group of bills that has been forwarded by the administration and by the AG's office dealing with discrimination, and this bill is focused on harassment. And the operative language, the first code section is just, should there be dismissal that is involved in a harassment charge, that would allow it to go forward as any other discrimination charge would be handled. But on line 42 is where you start into the bill before you. And the bill before you then defines harassment on the next page to also include sexual harassment. So we are including all of the issues that have become so public in the last several years, and defining sexual harassment as sexual advancement, a request for sexual favors, or any other conduct of a sexual nature where it's a condition of continued employment, the basis for an employment decision, or it creates an intimidating and hostile, offensive work environment. The workplace harassment definition then on the next page includes then the unwelcome conduct that unreasonably alters the individual's terms, conditions, privileges of employment in, again, an intimidating, hostile environment. And what you then have in the bulk of the bill then that starts at the bottom of page 3 are in fact, what the AG's office has used for a number of years in prosecuting, in investigating cases, looking then at all of these conditions to determine whether or not the totality of the circumstances, the frequency, the duration, who was involved, whether or not there was a power differential, all of these specifics that start on line 71 are all, again, those that have been used in looking at EEOC cases. And then finally, it outlines, starting on line 91, how the division under the Human Rights would approach these cases, what the responsibility would be for the complainant to put the information in writing that indicates time, place, and specific facts, the initial look at that, the investigative step through to determine whether or not there is a cause that the division would go after, and also then informing the complainant of their rights for a civil action should they choose to pursue it, so that they are well informed that it's not just a matter of the division going forward. And essentially, that is the outline of the bill before you.
All right, are there questions of the patron? Yes, Senator Boysko.
Mr. Chairman, a question for the patron. Wondering, I'm not an attorney. I know you're not an attorney. Could you explain to us how your vetting process has been as far as the language that you're using here? So that we understand
it
that
has
this
been
fully
ongoing. and actually, I'm sure there are, I would appreciate those in the room that have been working on this. This is something that has been from a number of different sources to make sure that, as I use the reference, package, so that what is being done in discrimination, that this fits in appropriately, and I will now leave it up to the attorneys.
Thank you very much, Chair and committee members. Andrea Johnson with the National Women's Law Center. I'm also a proud Alexandria, Virginia resident. And to go to your points, we've been working with state legislators across the country on anti-harassment laws, and 15 have strengthened their laws in the just past 2 years, which has really been unprecedented. And the protections that we see here in this bill are incredibly important because right now, workplace harassment isn't specified in the code in Virginia, nor is it spelled out in federal statute. So instead, we're seeing that the parameters of what constitutes workplace harassment has really been left to courts and judges, and the result has been varying court interpretations, too many of which don't reflect the realities of workplaces and power dynamics. So this is providing a clear statutory definition of workplace harassment that follows the intent of Title VII, EEOC standards, and then lays out guiding factors that are based in case law that courts can consider to avoid bad case law and bad frames of analyses that have really led to cases where you have judges finding that it's not harassment when a supervisor reaches up a female coworker's sweater and fondles her breast, finding that that is not harassment because it was just one incident. So bad case law like that has developed, and this makes these guiding factors are helpful to make sure that that does not replicate.
All right. Any
Follow-up
questions?
question, sir?
Mr. Chairman.
Yes, Senator Mason.
So, ma'am, you unfortunately got the wrong Mason in the family. This is what my wife does as a chief compliance officer. So, but you said that there's nothing in for her to follow, but this is what people bring these complaints to her every day. So what does she follow today as a guideline that this is either replacing or adding to, and is it structured around that?
So right now, there's nothing in statute that specifically talks about what the private workforce needs to do in relation to sexual harassment. It's all developed through case law. And the EEOC has some guidelines that came out in the 1980s that have been helpful as well. And a lot of that language is what we see in those guidelines, what we've seen developed through case law. So it's well understood language. It's just it doesn't actually exist in statute, which I think is surprising to a lot of folks. This is not codified, which has led to kind of widely varying court interpretations, and is a reason it's important to put the standard on the books and in a way that makes sure we don't avoid some of the pitfalls that have arisen in case law interpretations.
Mr. Chairman, one more.
Yes, Senator
So,
Mason.
ma'am, I know on our side, Senator Evans' bill, but we're hearing the similar one today. We've worked through the fact that a lot of what weeds out cases in her area is the EEOC process. And that doesn't exist in Virginia. So is this going directly to the Attorney General? Because there was some concern early on that it went straight to circuit court, and there's no mechanism in the state to weed out some of these, hey, it's not harassment, you didn't get promoted because of X, and it wasn't discrimination, it was, your employee reviews a lot worse than hers. Have we taken care of that in this bill, and is the Attorney General able to handle the additional caseload?
Yeah, so Megan Healy, Chief Workforce Advisor to the Governor. Yes, we actually took the language starting on 91, that same administrative process that you're going to see later in Sickle 1663, that goes through the AG's Office Administrative Process, very similar because workplace harassment is also under EEOC as a discrimination, right? Especially sexual harassment is a sex discrimination. And so that would be processed, the administrative process to the AG's office or the EEOC, and then that's what's the determinations come out of that. So that's helpful to the employers, right? Instead of sending everything to the circuit courts. And it also helps with employees because they want to take action. I don't want to sit out for 2 years and waste money as a lawyer to go through the court system.
Mr. Chair?
Thank you, ma'am.
Senator Boyko.
So looking at the FIS on this, it's $267,000 a year plus. Is this funded in the budget? Just curious.
Yes, and again, this is the reference to package. This is all part of the enforcement that has been in the budget.
All right, Senator Ruff.
Mr. Chairman, I understand what you're trying to accomplish, and I'm not saying it's good or bad, but there are two sides to every issue. If somebody brings a charge or brings a complaint, they have a cause of action. What is the cause of it? Does it give the employer the same right cause of action if it appears to be a stunt or revenge on the part of the employee?
Yeah, that's why we have the administrative process first through the EEOC currently to say if it's a relevant case as well as through the AG's office. And that's setting up to support the employers. Instead of just going straight to the courts. So they have an opinion on if it's relevant or not.
And what I would offer just is reading the language as it's been worked on by all the attorneys. Again, we pointed to 91 where the process is started to be described, but down on 104, you have the complainant and the respondent. And again, we start with something in writing that must be identifiable, time, place, and facts. And that is changed then, that is shared with the respondent. And then the next step is to make sure that they may agree to voluntary charge with a mediation without waiving any rights. So the division is also focused first on sitting down and looking at the facts of the case in voluntary mediation, so that the respondent, the employer, is very much involved from the beginning of the investigation. And again, the division may decide that there is nothing to pursue and that there still is a private cause of action that is possible. But given this investigation, given that the employer is aware of the situation, that really narrows down significantly what might ever end up in court as far as an independent action. And then the final point that I was impressed with as I have been involved with this, with all of the look at it, is that if the report after the investigation, and this starts on line 117, concludes that there's reasonable cause, the first step that the division would take under this bill is to immediately endeavor to eliminate any alleged unlawful discriminatory practice by informal methods such as conference, conciliation, persuasion, again, working with the employer. And only if that doesn't work is there then the possibility that the division may go forward with legal action.
Mr. Chairman, is
Yes,
there
Senator
any representative of employers here that would be willing to make that same statement? Apparently not.
All right, are there any other questions of the patron here? Senator Bell?
Don't know who would be best to answer this. Since the workplace harassment definition is new, I like the definition here, but what is the source of that? How was that derived?
Yeah, so it's pulling from Title VII and case law as well. So it's unreasonably alters the terms, conditions, and privileges of employment. Terms, conditions, privileges of employment is a term that's in Title VII and has been long there, so it's terms that employers are familiar with. This is talking about, hiring and firing and changing work assignments, things like that. And then the unreasonably alters piece comes from the Meritor v. Vinson Supreme Court case, which was the landmark case that established sexual harassment as illegal. And so it draws from that case. And unreasonably, it was inserted to really make sure we have an objective component to the analysis, given that all sorts of behavior could just merely alter the environment, but that doesn't necessarily make it illegal. It needs to be unreasonably altering it to make it illegal, so we're not just making any behavior illegal. So that's an important piece there that was included.
Mr. Chairman,
Senator
thank you for that. Small follow-on, is this closely matched, or would you say this closely matches what other states are defining this, or other, so we would be, many companies or international companies work across state lines, just want to make sure we have a definition that would be coherent with multiple location operations.
Yeah, I think what's relevant is that this closely follows federal law, which everybody has to follow. So, it's not a big change from that by any means. It's really based in that and trying to make sure that the factors are there to avoid some of the bad cases that have arisen. But so, yes, it would not create a lot of disparities between other laws, between other state laws. And not every state has codified the protection on the books yet. A lot have been doing that over the years as they realize the problems with not having it on the books. And just looking kind of through what some of the other states have, it is very similar language, submission to the conduct as a basis of employment. And yeah, same language, similar language.
All right, are there other questions?
Mr. Chairman,
Senator Boyce.
I'd just like to make a comment and then at the appropriate time make a motion.
Well, we haven't heard testimony yet, but other than.
Okay. Oh, I thought you'd ask for it. Excuse me.
That's right. Go ahead. All right. All right, is there anyone who wishes to speak in favor of the bill? Anyone who wishes to speak in opposition to the bill? All right, we have one coming forward now, so.
Mr. Chairman, committee members, Josh Hetzer, I'm Legislative Counsel with the Family Foundation. I want to just point out up front, it's sort of a technical matter, which the committee may know, this bill creates a section 3904, I believe, and there is also a section 3904 bill, new section under that number in House Bill 1663. So I think that the committee will need to decide the policy that it would like to send out, and I hope you keep that in mind. But I just really want to point out in this bill some of the ambiguities in the term workplace harassment. Some of it was explained about how the language came about, but there are other portions of this that I think are concerning and we should think about. It says regardless of whether it is direct or indirect, right? Whether it is verbal or nonverbal, it unreasonably alters the terms, conditions, or privileges of employment, and then finally including creating and intimidating hostile or offensive work environment. So I want to point out that these are very, very broad, vague, ambiguous terms in which only a court could figure out. And so I think we're really inviting a lot of unnecessary litigation. In the Family Foundation, of course, is always concerned about religious liberty, religious organizations. There isn't any exemption here for those, particularly with the new terms that are added with sexual orientation, gender identity. These oftentimes do create conflicts with religious entities.
Mr. Chairman.
Yes, Senator McPike.
A question of the speaker. What sort of religious exemption would you have for sexual harassment? I'm not sure I get the nexus of what you're speaking to.
Mr. Chairman, Senator McPike, in this bill, sexual harassment is underneath the umbrella of employment discrimination. So it would sort of, anywhere where it was unlawful discrimination practice in employment, workplace harassment would fall under that. So if for some reason somebody, let's take an example of pronoun usage. If somebody in a religious situation said, you know, I'm not comfortable using a certain pronoun that somebody would like me to use, that might be considered to create an offensive work environment. And so it would create a problem. There are any number of scenarios. So I hope that answers your question about some of the religious liberty concerns. So.
All right. Is there anyone else who wishes to speak in opposition to the bill? All right. Senator Boysko.
Thank you, Mr. Chairman. Delegate Watts, I want to thank you for bringing this up. I know this has been important to you for years and years, and finally getting the attention to it. I would like to ask if you have a response from the concerns that the gentleman just brought up.
The first easiest concern, again, in the package, this is why we have the duplicate numbers. You can't anticipate what is going to pass. So that's the normal process that you would go through, depending upon what passes, how the code will be laid out, right. Which section will fit.
Thank you.
Follow it. The answer to the broader question is again and again, using language that has been used for enforcement under EEOC, and that is language that comes from case law. Again and again, as I kept studying this, totality of the circumstances becomes a very important concept that is repeated again and again, and the degree to which something is truly threatening. I know when I was anticipating a possible question, and I think I will go ahead and use this example, on line 86, the conduct is also experienced by others outside the protected class. And I'm thinking, what example if someone asked me about that? And you could call everybody in your workplace boy, and you could call certain individuals boy with a definite message being conveyed that would be intimidating and threatening. And this is the kind of thing that there's a whole body of law and case study. Again, these are terms that have been tested, and I believe they do belong in our code, in our statutory body of law.
All right.
So, Mr. Chair, I move to report.
Mr.
All right,
Chair.
got a motion? Oh, go.
Yeah. Mr. Chair, I am,
Excuse me.
You asked if there was anybody else that was against this
Yeah.
particular bill. I'm just an individual. I'm just a parent here in.
Yeah. Yeah.
My name is Barbara Kearns. I live in Chesterfield County. And I was taking a look at this particular bill that you have before you. And I agree with the previous person from the Family Foundation about how general and vague some of the terminology is about offensive work environment or hostile. I mean, I'm a Christian. If I'm talking about my Christianity and somebody heard me, they might be offended by that because it could create an offensive work environment for them. And how does this relate to people who work at churches or religious organizations like adoption agencies, foster care? And if they were to be talking about their religious beliefs in that situation, or they have somebody that works for them and they are a Christian, they have certain standard that they expect them to live by, and this person comes in and they have their sexual orientation or their transgender or whatever, and doesn't fit with the church's thought and their standards. And if you tell them, well, hey, no, that's not acceptable here, well, now it's an offensive work environment, and you're creating a hostile work environment for them. So I think there does need to be some exceptions here for people of religious organizations. And there also needs to be a clear definition of these, what it's considered an offensive work environment. Thank you.
All right, we have a.
I renew my motion to report the
Okay,
bill.
we have a motion to report.
Mr. Chairman, I just want to tell Delegate Watts, I'm going to abstain on this. We've had some discussions on the floor of the Senate that have been bipartisan about a case law that is being converted into code, and it's created a lot of conflicts. We don't have time for this to go through courts, but even just today, there was a suggestion that some of the other bills that have passed through here in other committees should have gone through courts. I've emailed this to a bipartisan group. So I just want to make sure we've looked at all of that and the vagueness, and we've vetted this, as we would have if we'd had time for it to be looked at by lawyers, because none of us are. So I just wanted to clarify that, Mr. Chairman.
All right. Is there further discussion among the committee? All right, the motion is to report, and actually you'll need to amend that motion to report and re-refer to finance. So we'll go upstairs there. So, all right, so we have a motion to report and re-refer to finance. Let's vote on the board.
Ayes 8, noes 4, 1 abstention.
All right, was reported and re-referred to finance.
Thank you very much,
you.
Mr. Chairman, committee, and council.
All right. All right, next is Delegate Willett. This won't be as quick as you were this morning, so.
Okay.
When you walked in and turned around and went right back out.
That was fast. Thank you, Mr. Chairman. Presenting HB 935, and you should have a committee substitute for that.
Okay, good.
They were just some minor line amendments. Yeah.
Line amendments on it,
Okay.
House Bill 935.
Thank you, Mr. Chairman. Speaking to House Bill 935, this is a bill to streamline the reporting requirements for the Virginia Economic Development Partnership. Currently, there are a number of duplicative reports that have over the entity's history have accumulated. So this is their review through that to consolidate, streamline the reports, and also hopefully to improve transparency, because there'll be a fewer number of reports for the public to see, to understand what's going on, but it puts it in a more concise fashion.
All right, any questions of the patron? Yeah, well, do you have the amendments, council?
I could show you. You just know there were House amendments done. just make sure you have that version.
Oh, these were House amendments.
There-
Okay,
yeah.
we
Yeah,
have,
I'm
we have
sorry,
the
yeah,
House substitute, so therefore, so it's in
Yeah,
there.
so you should-
okay.
you should
Okay, I
have-
thought
it should
you
be
were
engrossed. Yeah, I'm
offering
sorry.
new amendments, so.
No, I'm
All
sorry.
right. Okay, is there any other questions of the
So,
patron?
Mr. Chairman,
Yes,
it looks like,
Mason.
Delegate Willett, it looks like quickly, rural stakeholders, high unemployment areas, any other bullet point highlight things that these reports calling out?
There are actually 8 reports that are eliminated because they're covered at other places. So I see strategic marketing plans, incentives reporting, their operational plan and budget, and basically they were overlapping requirements. So this consolidates that.
All right, if there's no further questions from the committee to the patron, is there anyone who wishes to speak in favor of this bill?
Hi, Mr. Chairman, members of the committee. Christy Morton with the Virginia Economic Development Partnership. Just want to say thank you to Delegate Willett for working with us on this over the years. Additional reporting requirements have been added both in the budget and in code, and this will really allow us to streamline that information. So thank you for that.
All right, thank you. Anybody else speak in favor? Anybody in opposition to this bill? All right, we have multiple motions and seconds, third, fourth, and fifth, I guess, to report the bill. Is there any further discussion? All right, this does not have to go upstairs, so we'll vote now on this measure. So,
Ayes 13, no zero.
all right, the bill is reported. Thank you very much.
Thank you, Mr. Chairman.
All right, next we have Delegate Ward.
Thank you, Mr. Chair and members of the subcommittee.
All right, House Bill 1650.
Yes, thank you. Mr. Chairman and members of the committee, House Bill 6050 does 2 things. It replaces the single definition for a small business in Virginia that's being used by the Department of Small Business and Supplier Diversity to certify businesses as small businesses with a new system that more accurately reflects what small businesses are like in the Commonwealth in terms of size and gross receipts, based on the U.S. Census data for Virginia businesses in 2018. And the bill codifies the provisions of Executive Order 35, Advancing Equity for Small, Women, Minority, and Service-Disabled Veteran-Owned Businesses in State Procurement Contracting. Right now, today, 92 to 95% of all employees in Virginia work for a micro business. These are small businesses that have from 0 to 25 employees, not 250. The only tool that has worked to give women and minority-owned businesses the ability to bid and win state procurement contracts is Executive Order 20 that was issued in 2014, and then it was reissued in 2019 as Executive Order 35 to include the service-disabled veteran-owned businesses. There has been progress seen already. Under Executive Order 20, women and minority-owned businesses went from receiving only $75 million in state procurement contracts out of $5 billion issued annually by the state to the private sector to approximately $3.1 billion out of $20 billion in 4 years. It's not equal access, but House Bill 1650 will finally open the door for equal opportunity and state procurement contracts for small businesses in the Commonwealth. I believe there are a couple of amendments that have been given by the governor's office.
Council.
Thank you, Mr. Chair. On line 158 of the engrossed bill, after is, insert at least 51%. Second line amendment on line 159, the engrossed bill after Romanet 3, insert together with affiliate. And the last one, line 164, the engrossed bill after of strike $2 or $2 and insert $3.
$3, so it'll be 3 million rather than 2 million? All
That's
right.
correct.
And line 164. All right, is there a motion to adopt the amendments? All right, it's been moved and seconded. Any discussion or questions? All right, all in favor of adopting the line amendments, say aye. Aye. All opposed, no. All right, the line amendments before us. Any questions of the patron at this point?
Mr. Chairman.
Yes, Senator Ruff.
Senate Bill, House Bill 1134 by Douglas Lopez deals in the same range. Can you tell me what the dividing line is between these?
I have someone who could explain it for you.
Thank you.
All right, thank you.
Mr. Chairman and members of the committee, my name is Gwendolyn Davis. I am the Minority Women Business Enterprise Administrator for Portsmouth Public Schools, and my volunteer work is with Equipping Businesses for Success Institute. The difference between what Delegate Lopez has proposed and what we're proposing is we don't have businesses on average in Virginia that have 250 employees. We just don't. What you have in the fact sheet in Delegate Ward's packet, it shows you the categories that are used by the U.S. Census and the federal government, SBA, for all small businesses in terms of categories, and they're actually based on what takes place in the Commonwealth of Virginia. So we don't, the average woman and minority-owned business is 0 to 25 employees. 92 to 97% of all businesses in the Commonwealth have 0 to 25 employees.
Any further questions, Senator Ruff?
I'm trying to understand, I think we all want to help small business, but when we start setting quotas, but we have one set of quotas for this group, another set of quotas for that group, do we have the capacity to meet the standards of both of those? And somewhere in here it has a goal of 42%. And we want to help small businesses, but at the same time, we have to make sure that we're taking care of the taxpayers and we're not having an end around where people can run the charges up.
Well, the definition that's in the code right now, Delegate Lopez's bill changes the or to and. That definition was adopted by the Small Business Administration in 1959. And when the Department of Minority Business Enterprise was initially set up by the Commonwealth, it came up with a broad definition that it actually copied from the federal government, which is not reflective of Virginia businesses. So women and minority businesses have been kept out of the procurement process. I mean, when you're talking all blacks, minorities, Indians, Asians, and other groups only getting $300,000 statewide out of $5 billion issued, women and minority businesses combined only receive $75 million out of $5 billion issued, and that doesn't include the $16 billion that we issue in construction. So if you actually added that in, the numbers would be even lower. So the executive order is a race-neutral, gender-neutral tool, the only one that has ever worked in the Commonwealth of Virginia to allow women and minority businesses to actually bid and win state government contracts.
All right, Senator Boyce-Gill.
Thank you. I have a question, please.
Yes, ma'am.
So I'm responding to a question from one of my constituents who, I live in Northern Virginia where there is massive construction going on. I have the Silver Line Metro, I have Dulles Airport, I have just huge amounts of construction going on, and was requested to see if there might be a chance of exempting capital outlay pre-planning studies for projects that might be over $2 million in construction.
Okay, that's not included in this bill. This bill is about the discretionary spend. The construction is not even included. See, when they did the disparity studies, the initial one included construction. The second one just included the discretionary spend, so it's, no ma'am. It's separate.
So.
It's bad.
Follow-up
Madam
question.
Boysko.
Just to clarifying, so the, pre-planning construction would not even be part of what this bill would cover then?
And this is SWAM, small women
Okay.
and minority-owned businesses, discretionary spend money.
Thank you for the clarification.
Yes, ma'am.
All right. Any other questions of the
Mr.
patron?
Chair- Mr.
Yes,
Chair.
Senator Mason.
So, Delegate, this is maybe not a question you even want to answer, but you and Delegate Lopez's bill is drawn to the same code. His says 250 employees and $10 million, right? You're defining, you go on to define micro business, but you're
Yes.
saying under 25 and under, what did we say, 3 million?
Right,
And they both passed?
yes.
I mean,
Well, this is a bill,
How's
first of
that?
all, let me explain. I've been carrying this bill for like 4 or 5 years.
you have.
Um,
But Mr. Chairman.
I
You
understand.
see where
that.
I'm headed?
I
mean, how do we
understand
pass
where you're
both
going.
things?
I understand what you're saying.
Not your committee, right?
This is
Senator
my
Mason, let
bill.
the patron answer, so.
Yeah. This is the one that I'm carrying. This is the one that I believe in. Because you think of your small businesses, especially in those places like Williamsburg and places like that. You don't have small businesses with 250 people. You have a small restaurant, even here in Richmond. You set up a small restaurant. How many people do you have employed? Maybe 25. So those are the ones that I'm trying to make sure that when we're doing a definition of what a small business is, I want us to look at those that are most likely in our areas, in our neighborhood, not 250.
All right, thank you. Any other questions? of the
Mr.
patron?
Chairman.
Yes, Senator Bell.
Two questions. First one's kind of a follow-on to Senator Mason's question, because I'm confused by this too. I don't see how, if your bill goes forward, since you define this, and frankly, I like your definition, how that could coexist with Delegate Lopez's bill.
It may not.
Okay.
Senator Bell.
Is anybody, thank you, Mr. Chairman, is anybody from SWAM here, or anybody from the administration can talk about that? Because I think as we look at this bill, we're kind of making a decision on both.
I do think that it's up to someone else to come and address. I don't think we've done action on Delegate Lopez's bill here.
Mr. Chairman, she's so nice, isn't she? Is anybody from the administration can talk about how we're doing on goals right now? Because that's my frankly only concern, how we can meet these goals, or if it's realistic or not.
I'm not from the administration.
Yeah.
The goals that are usually set are aspirational in nature. They're not concrete.
Right.
Even at the local level, they're all aspirational.
All right, any other questions? All right, is there anyone?
Mr. Chairman?
Yes.
It's my
Senator McLean.
understanding that the governor is also looking at this with the work group, is that correct? And when are they due back with the report? Because this committee has addressed, Mr. Chairman, a
Right.
number of different sort of parts and components over the years without getting really a holistic review, as well as any sort of real data from the Department of Small Business Diversity, and that concerns me as we continue to receive bills without the data that supports our decisions, and that, I like the definition, I like where you're going, but I'm concerned about the number of different moving parts and components, and that we seem to struggle every year without having the administration even here to speak to it, which is frustrating, frankly.
Well, all of the data that you have is from the administration. I mean, we give the delegate exactly what we received. But with regard to Delegate Lopez's bill, several have been introduced by him to put our businesses in the categories. They were just too high. The federal standards were too high for Virginia businesses. So what Delegate Ward did was she looked at each of the categories with us and came up with, based on the census data, what Virginia businesses actually look like. So he's been supportive of the concept of the different categories all along.
Mr. Chairman,
Yes, Senator Rupp.
if we've looked at this over the years, I think we've figured out that 97% of the business in the state fall under that category that currently exists, which I think is ridiculous. And I like the direction you're going, but I don't know that we're at the point that we've got everybody on the same page. You got two different bills coming from the House that do two different things, and they're targeting, I'm not sure that your whether the set-asides they can fit in both categories or just one category. And I think we really probably ought to carry this over and look at it for a year and seriously look at it.
Mr. Chair, members of the subcommittee or committee, all of these amendments are from the governor's office. These are not anything I wrote. And this is evidently, when they wrote it, this is what he felt he wanted. And it's something that we're going by now. We're living under executive order. We did under executive order 20 and then 35. And so we just wanted to put it in the code. And that's what we're trying to do, put it in the code.
Senator Rupp, I can actually address the conflict issue.
Excuse me, Delegate Lopez?
I think I can address the conflict issue.
All right. Why don't you step forward and address that then? I think it would be helpful for the committee members here.
Thank you, Senator Barker, members of the committee. The definition for SWAM procurement in the state code is several pages long. However, it comes down to a fundamental issue of one size fits all with regard to what our basic definition is, 250 employees or 10 million annual revenue. What Delegate Ward's amazing bill does is it addresses the issue that we've been working on for years regarding the micro business, the micro targeted businesses, the actually tiny businesses. What my bill does, in a very different part of that very long definition, is to address the bad actors who are at the top of the scale. The people who are technically $1.7 billion corporations that technically qualify as small businesses in the Commonwealth of Virginia because they have only 19 employees because everyone else is a 1099. And so we address two very distinct and different parts of the SWAM definition and the SWAM procurement process in Virginia. I'm dealing with the bad actors at the top of the scale, and my legislation really only addresses the 4.4% of the top, and her legislation deals with the true micro businesses that are in mom and pop shops, in garages that are trying to grow and create something new and wonderful.
All right, thank you. All right, is there anyone who wishes to speak in support of Delegate Ward's bill?
I'm here to represent the chair of our committee in Portsmouth. We wholeheartedly support this bill. We believe the codification of Executive Order 35 is exactly what Virginia needs to move women and minority businesses forward.
All right. Anyone else? Anyone in opposition to the bill?
It's not opposition. Mr. Chairman, members of the committee, Patrick Cushing, on behalf of the American Institute for Architects and American Council of Engineering Companies, I am not here to speak against the bill. Our associations don't have a position on it, but I do want to highlight one issue that we've identified and just something to think through. I have some potential language for an amendment, but wanted to explain how architectural and engineering services are procured in the state and how the goal of 42% could impact how those are procured. When a procurement for architectural and engineering services, professional services, also includes CPAs, doctors, lawyers, when a state puts out an RFP, the process in the Virginia Code in 2.24302.2 says that the agency ranks the most qualified offerors from one down and then engages in a negotiation with that top-ranked offeror. The reason for that is for the professional services, the state wants to make sure that they're getting the most qualified entity to, for example, design a bridge. And so that's how that process is structured. There is no conflict with the 42% goal, but one of our concerns is that as agencies look to meet that goal, if they keep increasing the ranking of, or the percentage of scoring on a procurement for small business. If it's 10%, you're probably still going to get the most qualified offeror. But as you increase the number of points that's given to be for a small business responding to that procurement, the more you are degrading the qualifications component of that solicitation. So it's something that I think is really would be a friendly amendment to the patron's bill, but the concept would just be to make sure that in working to meet the goals established by this section, state agencies would ensure that any solicitation for professional services comply with the provisions of Section 2.2, 4302.2, and not impact the agency's ability to negotiate with the most qualified offeror. So it's really just an amendment that would be a signpost to another section of law that says, hey, look, as you're going to meet this 42% goal, make sure you're not also violating the Procurement Act in doing so. So I don't think it's really a substantive change to what the bill is doing, but if the committee is inclined to act favorably on it, we would ask that you would add that amendment.
Mr. Chairman.
Senator McPike.
Question to the Speaker, Mr. Cushing.
Yeah.
Would you not agree that when a responding firm responds to an RFP, when they put together the response package, they follow the RFP guidelines, including in such case, it could include diversity, microbusiness, others in terms of the respondents. And actually, that's one of the things that they look to guide both in their qualifications and the team that they're putting to the table.
Mm-hmm. Mr. Chairman, yes, that could be a component of the solicitation.
And so how would this be in conflict with responding to an RFP when I don't see, would you not agree that they could be completely built within the RFP and not in conflict at all?
They could be, but I think what ours does is to make sure that we have a qualifications-based selection process that's looking at the experience and qualifications of the offeror to design the building, design the bridge, or represent the state agency on behalf of the Attorney General's office. And so what we want to make sure is that as agencies are putting out solicitations, and it's typically a scoring, right, 0 to 100. So you could have a 10% score on whether you're a small business or not, and maybe that won't impact being able to negotiate with the most qualified offeror. But if that component of small business is 50% of the score, you may not be negotiating with the most qualified offeror. And I don't know if that's the best policy and situation for agencies to be in the Commonwealth.
All right. The bill is before the committee.
Mr. Chairman, I really think that this is a great idea, but I think it's not quite where we need it to be. And I think if we've got the micro governor executive order, that should take us through the year. But you use a definition of 25 jobs. I know of a fast food restaurant that's got 40 employees. And you couldn't call them much more than a micro business.
No, sir. The reason the micro set aside was put in the bill was because we were getting no work. The governor put 0 to 25 employees in there because he looked at the demographics for Virginia businesses and women and minority-owned businesses. The disparity studies conducted in 2004 and 2010 clearly showed that the ratio of women and minority businesses to the number of contracts issued is 10 to 1. We have 10 to 1 qualified women and minority-owned firms for every contract that's issued by the Commonwealth of Virginia. So the micro business set-aside was to give us some kind of entry into the system. It was shutting all women and minority businesses out. It's time to codify Executive Order 35. And because the governor liked the numbers so well, he reissued Executive Order 20 into Executive Order 35 and enhanced the provisions on July 3rd, 2019.
Mr. Chairman, I move that the bill be carried over to next year with a study.
Second.
All right. Motion and a second to carry the bill over to next year. Is there any discussion or questions on that? All right. We vote on that motion then. Open the voting thing.
Ayes 11, noes 2.
All right, the bill is carried over. We will send a letter presumably to the Small Business Commissioner or something, which we've been dealing with this issue for a few years, and hopefully we can
About
get a
7
resolution.
or 8.
Yeah.
Thank you, Mr. Chair, members of the committee.
Thank you. All right, next is Delegate Simon.
Can we do Delegate Lopez since it's the same issue? I'll defer to my roommate.
So, Mr. Chairman, if we had just passed that bill, his bill would by nature be dead. Is that right?
No.
No, what he was saying,
her bill-
Mr. Chairman? Wait, let me answer. What he said earlier when we had him come up was that those dealt with two different sections there. And one was basically saying how money would be spent. The other was saying how you didn't want to handle, difficult, some situations that were, where it would not be appropriate. So I think that they are in two different sections there.
So, Mr. Chairman, in 2.2.1604, Delegate Lopez says that together, 250 and an average of 10. That's his bill.
Right.
Her bill in 2.2.1604 strikes that entire paragraph. And I mean, hopefully we'll put them
Yeah.
in a place we can figure it
Yeah.
out, but there's no way, I don't understand how you passed them both. Right?
I don't, Mr. Chairman, members of the committee, I don't actually have a copy of Delegate Ward's bill, and I've only worked with her in the past on her bill. My legislation, which is a very different thing, only deals, as I said before, with the worst of the bad actors who are taking advantage of our SWAM procurement system because of the one-size-fits-all definition we have in Virginia. This legislation, by simply changing one word from or to and, only keeps out 4.4% of the folks who are availing themselves of our SWAM procurement system. And until we actually have this robust conversation about how we fundamentally overhaul our SWAM procurement system and fundamentally overhaul what we need to do about getting rid of this one-size-fits-all approach, and I have definite ideas about how to do that, this small fix will help truly small businesses thrive and survive, and we can make the SWAM procurement program be even more effective. And Senator Ruff and I, who've worked on the Small Business Commission for years together and had numerous conversations about this. In fact, we worked together on aspects of this legislation for the last few years, and we got it out of general laws on the House side, and we got it pretty far. He has heard the chimes at midnight with me on this. And I got to tell you, this is, like I said, a small fix.
We all heard the chimes at midnight last night. So.
Yes, we did, yes. I got to tell you, what we have here is a small fix to a much bigger problem that will help folks in the short term until we're able to truly change how we do our definition of small business procurement in the state.
All right, Senator Ruff.
Mr. Chairman, yes, Delegate and I have worked on this in the past, and the issue is, are those the right numbers? Should it be one size fits all?
Right.
And that, there are probably 10 different opinions, how many people are here right now, on what the right size is. If we're going to seriously study the other bill, should we not look at both of them at the same time and try to come up with some serious definitions, for a road contractor that's building bridges?
Right.
It's a different scenario than somebody selling pins.
Well, just, Mr. Chairman.
Delegate Lopez.
Senator Ruff, members of the committee. We've had this conversation for the last 8 years. And the fact is this, I used to be the assistant administrator of the U.S. Small Business Administration and the Obama administration. And what we have right now is a system where you're comparing apples to oranges to pears to bananas. Because a definition of a small construction company is not the same definition of a pizza parlor. It's not the definition of a Tyson's Corner small technology firm. And that's what we have right now with this one-size-fits-all approach. Basically by saying, and this has been in the code for years, these numbers of 250 employees or 10 million annual revenue have been in the code for years. The problem is you have companies that have been gaming this system and taking advantage of this system for years as well. Because what they'll do is they might be a $1.7 billion corporation, McManus Corporation, based out of Baltimore, Maryland, that it qualifies as a small business despite the fact it's a $1.7 billion corporation. It qualifies as a small business corporation in Virginia under our current one-size-fits-all approach. By making this one small change, you're actually fixing things in the short term. And we've had this conversation as well. What you really need to do is apply the federal NAICS codes, the federal NAICS system of the SBA, which actually has every industry broken by every subcategory of every industry, and apply that to Virginia because it's updated every 3 years because they say what a small tech company is, what a medium tech company is, what a large tech company is, and what a small heavy construction company is, a heavy transportation company is, and what a small barbershop is. That's what we need to follow. It's all online. It's incredibly easy to do.
All right, but that's not in this bill.
That's not this bill.
So-
This bill, instead of that 20-page document I'm thinking about in my head, is a one-word change that gets rid of those worst bad actors.
Senator Ruff, you want to? No. Okay, all right. Yeah, Senator Briscoe.
Mr. Chair, thank you for the patron. So gross receipt, you have gross receipts here, right? Average, you have 250 employees and
10 million
10
annual
million
revenue average over
in
3 years.
gross revenues.
Right.
I again, you weren't in the room, but I represent a community where there is massive growth going on, tons of construction, huge projects.
Right.
And the many of the people who are doing those work, the equipment that they have to use is terribly expensive. Would you be willing to look at something along net, like the net receipts, the net profits or annual revenues as opposed to gross? Because it was explained to me that.
Yeah, yes, I would, but I'll also tell you that 95.6% of all businesses in Virginia qualify as small. So who gets hurt? When we're comparing under the SWAM procurement process, small, women, and minority-owned businesses, the people who get hurt are the women and minority-owned businesses. Because if everybody qualifies as small, what do our procurement programs mean? Nothing. They mean nothing. It's paper. So all I'm asking is that if you want to make that amendment, I would view that as a friendly amendment.
Mr. Chairman.
Senator McPike.
I'd say, maybe propose a question to the delegate, would it not? I mean, there's a lot of moving components within these code sections, and what I fear is based on some of the data, there's a domino effect is we pull the string one way, and now we're inadvertently harming someone else. And so, frankly, that's one of the concerns I have in looking at this, and I really want to get the data to dig in and make sure we do the right thing to do the target. I think everyone on the committee wants to do and get to a position where we're helping the small businesses that need the help. I am uncomfortable right now based on the lack of data, based on the lack of administration, based on the lack of the Small Business Diversity Office not being here, and the data, much like Delegate Ward's, bill as well, that, I still have the same concerns with this bill as well. And so I appreciate the delegate's position on it, but I don't know if we're going to take additional comment on it, but I think sort of heard the issues.
Well,
yeah.
Mr. Chairman, members of the committee, I will actually say that because we have worked on this for so many years, it has been studied. We actually did go through and have a fairly, exhaustive series of conversations with the former governor's administration, where we got into the weeds, we made the changes, we put forward legislation that went further than it had ever had with the minority caucus on the House side. So the data is there, and I'm more than happy to get in the weeds with anyone on what the figures are. But the fact is that I understand your concern. You pull a string here and the whole industry collapses over here. That's really not going to be the case. with regard to this one small fix.
All right.
Mr. Chairman?
Yes.
I
Senator
wanna-
Bell.
Thank you, Mr. Chairman. Bad actors. What are you calling a bad actor?
I'm calling a bad actor who is someone who takes advantage of the intent and the spirit of our SWAM procurement procedures by saying that they're a small business when they're a $180 million corporation. And they're competing for paper supplies against actual small businesses because they technically have less than 250 employees. All right? I'm talking, and we're literally, like I said, let me repeat this. It's 4.4% of the businesses in Virginia that are currently taking advantage of the small definition would be affected by this change. 95.6% would not.
You're just repeating yourself.
No, I know, but it seems like,
Mr. Chairman.
Yes, Senator Donovan.
I just want to point out that we have a JLARC study going on now that is the Department of Small Business Supplier Diversity. We have the administration study that's going on. One of the greatest dangers to our small businesses and business community is constant change. It has to be predictable for a business community. And so we're going to make changes next year because those two studies are going to come back and we're going to decide how we make a change. And I'm going to make the motion, Mr. Chairman, that we continue this to next year, complete the studies like we did with Delegate Ward's bill.
Okay.
Chairman Barker, just one point. Those studies are not specifically about the overhaul of the definition.
Okay. So we have a motion to carry over for the year. Is there a second?
Substitute motion?
Mr. Chairman?
Yes, Senator Bell.
I would ask before we make motion on this, would it be possible to hear some testimony from people who may be here to speak either for or against this? Because we haven't heard anybody on this particular bill.
Well, we did with the other one, but okay. Is there anyone who wishes to speak in favor of this proposal? Is there anyone in opposition to this proposal?
Years.
Mr. Chairman, Rob Bohannon, representing the Richmond Area Municipal Contractors Association. These folks are heavy contractors, site prep, water and sewer line construction. No doubt what Delegate Lopez says is accurate. I can only speak from the heavy construction industry. You know, any system probably has bad actors in it. The issue is you have a one-size-fits-all definition that Delegate Lopez's bill trades for another one-size-fits-all definition. The issue with heavy contracting is that $10 million you can get to very, very quickly. If you can imagine, you know, most contracts with the Commonwealth have a small business set aside. And so why a state legislature should care about this is a specialized heavy construction contractor could accomplish that job for the Commonwealth. You make that definition harder to meet. You now have a set aside for small business. You now need more small businesses to meet that goal, to get to that level, to prepare that site. That can lead to higher cost. That can lead to more delays. If you have multiple small businesses on the job site at one time in a construction, think about if you have a renovation at your home and you've got all these different folks on the site at one time. Virginia has the goal of 42% small business participation, which is great and acceptable. For VDOT, they currently hover around the mid-30s at their highest in small business participation. As you heard on the previous bill, those are aspirational goals, and we get that. But if you make this definition much, much smaller, you're going to get down into the 20s, probably about half of what you are. You're actually going to have less small business participation. And most of you I know have met with various members of ours who are heavy construction contractors. These are not, the $1 trillion companies we're talking about, or the $1 billion companies Delegate Lopez mentions. These are labor intensive. And again, when you are a heavy contractor, high equipment costs, high labor costs, a lot of what you make, that $10 million will be passed through costs to subcontractors and to equipment suppliers and to equipment leases. Also, it's worth pointing out, a couple people have talked about the small business definition at the federal level, and I went and actually grabbed the latest chart that the U.S. Small Business Administration uses, and Delegate Lopez mentioned this. They go through industry by industry. Just to let you know, for a couple of things that our members participate in, highway, street, and bridge construction, You're a small business if you're 39.5 million in revenue. Water and sewer line construction, 39.5 million. Site prep, 16.5 million. $10 million is way, way, way below that number. And that's sort of the larger issue here is you're going to have two different systems that folks would be
Yeah, there
involved
clearly
in.
are differences on terms of what type of industry you're in, so.
That's right. And that's why, I can only speak for heavy construction, but I know, there's a bunch of different folks in that small business category.
All right, is there anyone else who wishes to speak in opposition to the bill? All right, we have a motion and a second.
Chance to speak to that?
Carry it over for the year.
No chance to speak to that?
Well, just very, very
All right,
briefly,
that's, the RFP process is, it has set asides for small businesses, but if no one can meet the small business standard, then you're not losing out because you're not being able to say that you're a small business. And yes, we do have a need for a comprehensive reform, and I think I see where this is going, but we will be talking again in the future, and hopefully you will all be on board with this process.
All right.
And not ignore the incredible weight of data that's out there.
Next year, just bring that paperwork and put that in.
There you go.
All right. All right, we have a motion and a second to carry over for the year, which is what we did with Delegate Ward's bill as well. Is there any further discussion in the committee? All right, we will vote on the board.
Ayes 13, no zero.
Ayes 13, no zero. Thank you very much. All right, next is finally, Dick, we have the delegate assignment, so.
Thank you, members of the committee. I think hopefully this one will be an easy one. It's, one of the things I love about the General Laws Committee I serve on the House is you get to shift gears from
That's right.
contracting
One to
and
the
small
other.
business to condo terminations to anti-discrimination stuff. So it's going to be an event. I'm sure the audience is learning much more than they ever thought they would about small business procurement. Thank you.
Yes. All right, we got a motion and a second to adopt the substitute. Any discussion or questions? All in favor say aye. Aye. Opposed, no. With the substitute is before us, and present Delegate Simon.
So, Mr. Chairman, members of the committee, this bill updates the condo termination statute. So we created, condominiums started to be created, first had the Horizontal Property Act and the Condo Act years ago, and nobody really focused a lot on the termination provisions because they're being built. We figured that problem would be 30, 40, 50 years down the road. Well, here we are now, 30, 40, 50 years down the road, and we've had some condo terminations in the Commonwealth recently. And what this bill seeks to do is simply make some technical changes to try and prevent people, I'm going to be sucked into using the term gaming the system. But it prevents someone, for instance, from putting a very large lien on their property and then making the rest of the condo folks pay off that lien as part of the termination process. It changes the way that you allocate the proceeds of the sale based on the fair market value of the property and then your common element interest in that. And so it's been worked over by some really good condo and community interest attorneys, including Pietro Gianni and John Farrell. They actually had some differences. They came together yesterday thinking they'd testify about this bill, worked out their differences. Of course, we didn't have a meeting yesterday, so they're not here to further explain that. But that's essentially what the bill does. It's mostly technical, mostly just to keep people from gaming the system now that we've had some experience with some condo terminations in the Commonwealth.
All right, any questions of the patron? All right, is there anyone in the public who wishes to speak in favor of the bill? Anyone in opposition? All right, the bill is before, the bill is the substitute.
Mr. Chairman, you're representing that this was a compromise from your original to this, is that?
Senator Ruff, that's correct. And it was mostly, frankly, a couple lawyers wanting to style it up together, but they got together and agreed this is the best language.
Okay, thank you.
All right, we have a motion to report in a second. Is there further discussion in the committee? All right, we will vote on the board.
Fair enough.
Ayes 11, no zero, 2 abstentions.
All right.
Thank you, Mr. Chairman, members of the committee.
All right, next is Delegate Keem.
Good evening, members and Mr. Chairman. House Bill 1333 is a fairly new concept in Virginia, although it's not a difficult concept to understand. The issue that we're trying to address is the cash crunch that some renters may have as they're trying to rent their apartment for the first time or a condo. As we know, the current standard practice is for a new tenant to be able to come up with some cash for a security deposit, and it's usually 1 month, maybe 2 months rent. And for some people, that's not a problem, but for many people, it is a problem in terms of having to save up that cash. And I do have a substitute, which I'd like to present first, and I can talk to you about what the substitute does.
Motion and a second on the adoption of the substitute. Any discussion on that? All in favor of adopting the substitute, say aye. Aye. All opposed, no.
Thank you, Mr. Chair.
All right,
Members,
that's substitute's before us now.
Sorry, I forgot to apply the substitute. By the way, I want to thank the council, and especially Ms. Binge, for her very generous and patient time in helping me with the substitute the last couple of days. So the issue that we're trying to address is how do we allow for people that are qualified to move in without having to worry about coming up with the cash? And so there are some states and some counties, and even in Virginia, some people have experimented with surety bonds. It's a way to say that instead of coming up with cash, you can just pay like a monthly premium to have a form of insurance. What this bill would do is actually codify that concept as not just a surety bond, but an actual insurance product. Now, my understanding is that there are some companies that are developing these products as we speak, and so the bill as it's drafted now is a discretionary. It allows for landlords and tenants to be able to negotiate and come up with a kind of an alternative to cash security in the form of insurance. And so we've drafted this bill in a way that allows for landlords and tenants to do so as long as they meet certain criteria in terms of licensing and all the various requirements of insurance. The substitute before you that's different from the original version is that I work with our insurance folks from the independents to the property casualty to make sure that the language we use in this code section complies with all of the Bureau of Insurance language that they use generally for insurance purposes. And that's really all it does. And just the only thing I'd say, Mr. Chairman, is my understanding is that we're one of the very first states that are looking at this from a statutory language as this new product is hitting the market. All these financial technology companies that are developing these new innovative ways to help with the cash crunch. My hope is that by doing this, we send a signal to the financial marketplace to come and work with us in Virginia, provide this opportunity so that those people that can't come up with the cash can still move in, face our low-income housing situation, and hopefully at some point this becomes a standard practice in Virginia and elsewhere in the country. So with that, be happy to answer any questions.
Delegate King, just real quickly, I assume from sort of skimming through this that the substance of what you're talking about is on page 10, the last page of the...
Yes, sir, Mr. Chairman. The rest of that is just technically making sure that the language, whenever you say security deposit, it allows for insurance. But it's exactly. It's
All
the
right,
last
are
page.
there other questions of the patron?
Mr. Chairman,
Senator
it's
Ruff.
purely permissive. Landlord chooses to do it.
Yes, sir. Senator Barker, Mr. Chairman, I tell Senator Ruff that originally when I drafted the bill, I just thought it might be a good way to say we should do this. And then in the House process, it became a permissive bill, and so that's what it is now.
All right, Senator Donovan.
Yes, thank you, Mr. Chairman. Is code needed for this to be allowed in a contract, or can people just choose to do this?
Mr. Chairman, Senator Donovan, the reason why we're putting this into code is because I've checked with our Bureau of Insurance, and our Bureau of Insurance believes that as long as you're licensed and such, they think they can, qualify under certain existing rules. But in the housing section, in the landlord-tenant language, because we only talk about security deposit generically, if we don't specify that there's also an insurance that could be substituted for that, the landlords might say, well, I'm not sure if I'm allowed to accept this as a product. So we wanted to just be sure. And on top of that, as a consumer protection measure, if we wanted to have companies that wanted to come in and offer that, whether it's surety or insurance, we wanted them to go through the licensing processes, what amounts that it ought to be, and what kind of rules and rights should the tenants have if they want to get out of that contract. So that's what the language does here, is to protect some consumer protections in this section of the code.
All right, any other questions? Yes, Senator Urban.
When it's appropriate, I have a motion.
Well,
Mr. Chairman.
Yes, Senator Bell.
A quick question. Sure. I think I know the answer to this, but I just want to make sure this doesn't change if they can do 2 months, which is already in the code. Mm-hmm. But if they want to have the insurance cover, say, more because the person has a pet, or 1 month if they don't, for instance, 2 months if they do, 1 month if they don't, they could adjust the insurance for those situations?
Mr. Chairman, I tell the delegate, Senator Bell, that the goal here is to try to come up with the equivalency so that if it was cash, it would be cash. Now, the only difference, of course, is that we're not talking about rental insurance, which the tenant would be responsible for. If they have something that they want to protect for themselves, they get their own insurance. This is to protect the landlord. So if the landlord says, I need you to give me this amount to protect my property, that's what we're talking about. So it would be equivalent to what the landlord would want in terms of their security deposit.
Mr. Chairman, thank you.
Senator Bill.
I thank the patron for bringing this bill. I think I've heard of this program other places. I think it's a great, innovative idea, and will relieve the burden on many people. I'm ready to make a motion at the appropriate time.
All right, well, first we got, see if there's anybody in the audience who wishes to speak in favor of this proposal.
Nobody?
No, there is somebody coming forward here. So.
It's getting late.
Mr. Chairman, Christy
You actually have
Mara.
supporters for a change, so.
Christy Mara with the Virginia Poverty Law Center, and we thank Delegate Keane for bringing this bill. We do support it. We know that one of the barriers for people finding safe, affordable, and sustainable housing often is the large security deposit that 2 months can be. We think this will be something that can provide tenants with a way to pay a more reasonable amount and still protect the landlord's property at the same rate. So we ask you to vote in favor of the bill.
All right, next.
Thank you, Mr. Chairman, members of the committee. Brian Gordon on behalf of the Virginia Apartment and Management Association and the Apartment and Office Building Association, and we also support the bill.
Thank you.
Good afternoon. Excuse me. Joe Hudgens with the Independent Insurance Agents of Virginia, and we support this wholeheartedly.
All right. Anybody wish to speak in opposition to the bill? All right, the bill's before the committee.
Mr.
Senator
Chairman, I would move that we report this fine bill.
All right. We have a motion and a second to report the bill. Any further discussion among the committee? All right, we'll vote on the board.
Ayes 13, no zero.
All right, the bill is reported.
Thank you, Mr. Chairman. I
Thank you.
appreciate your time.
All right, next is Delegate Simons.
Good evening.
Yes, it is evening, but it's still 6 hours before when we ended last night, so we got a long ways to go, so.
Mr. Chair, may I speak to the bill?
Yes, you may. This is House
was
Bill 932.
Yes, I was fortunate to be the chair of the board for DPOR. And so when I came to the General Assembly, they offered for me to carry this deregulation bill for natural gas auto mechanics and technicians. HB 932 deregulates the certification program for natural gas auto mechanics, of which there are zero regulants right now in the state of Virginia. And this bill implements some of the recommendations of the JLARC report to eliminate unnecessary occupational regulation. And we do have Mary Brisvon from DPOR with us today, if you all have any questions for me.
All right, are there questions of the patron now? All right. If there are no questions, anyone in the audience wish to speak in favor of the bill? Anyone wish to speak in opposition to the bill? All right, we have a motion and a second to report the bill. Is there any further discussion among the committee? All right, we will vote on the board. All right.
Ayes 12, no zero.
Ayes 12, no zero. The bill is reported. Thank you very
Thank you.
much.
Thank you, Senator. Thank you.
All right, next is Delegate Levine. And Delegate Levine, we spent about an hour with you last week.
We did.
So let's try to keep it to a minute or two here, and we'll move quickly into this.
I'll do my best, although there are people here that weren't able to speak last week. But I'll say this. This is a very important bill. And before we get into the very specific weeds on a very specific section of this bill, and I'm sure we're going to do that again, I want to remind the committee what this bill is all about. This bill says that gay Virginians, lesbian Virginians, bisexual Virginians, transgender Virginians are full and equal citizens of the Commonwealth and should not be discriminated against on the basis of their sexual orientation or gender identity. And it says throughout the code. And I can tell you, as a gay Virginian, this bill is very important to me. I probably take it personally, and there are a lot of people in this room who do as well, that they're filling the seats behind me. This has to do with the question of whether we have free and equal rights under the law. Now, the only section that was complained of, you'll remember, was last week, and it was section 2.24201, basically lines 213 to 236, the contracting clause. I guess I should be pleased that out of a 39-page bill, that was the only section that was complained of. But one of the things that's important in that section and was not pointed out last week was if you'll read 217 to 220, you'll see that the law already takes account of bona fide occupational qualifications based on religion. It says, and I quote, 217, "The contractor will not discriminate against any employer applicant for employment because of race, religion, color, sex," it adds sexual orientation, gender identity, "or national origin, except where religion, sex, or national origin is a bona fide occupational qualification reasonably necessary to the normal operation of the contractor." So if you need to have religion as an occupational qualification, that's allowed in current code. In fact, in current code, you can even discriminate on the basis of race and color and sex and national origin, as long as religion is a bona fide occupational qualification. So that's current law. Now, it was brought out last week, you'll remember, there is an executive order put forward by Governor McAuliffe to say there should be no discrimination on the basis of sexual orientation or gender identity. If anyone wants that executive order, I've got lots of copies of it. I'm happy to pass it out. Maybe I should, just real quick.
Delegate Levine, since we spent an hour on this last week, could you try to move it along as quickly as you can?
I'll move it along. There's also the Religious Freedom, 57.202. There's also the First Amendment. There's also the Virginia Religious Freedom Act. The point is, already there are guidelines, and they're right about this. There are guidelines that allows and have allowed Catholic charities to do all the good work they've been doing for a long time. These guidelines are allowed under current law, and this law does not change current law with regard to contracting, because, in fact, the executive order is identical, because I tried to include it in here, but it's basically already identical in the bill. So they're already covered. They don't need additional guidelines. And in fact, the guidelines actually make reference to other laws and regulations that aren't even part of this bill. So I suggest to you that they can continue to do what they're doing.
Mr. Chairman.
Senator Donovan.
Thank you, Mr. Chairman, and I am very grateful that the patron allowed us a week to look at this and see. I have given a copy of the guidance document to everybody on the committee. We have a substitute. There's actually two portions of the contract that relate of the bill that relate to contracting that this would be relevant for, and in those two, can we give out the substitute? In those two sections, and it is specifically 2.2-4201 on line 214 and 2.2-4311 on line 355.
Line 355.
214 and 355. And so this is the exact language modified, because the original language referenced paragraphs in the executive order, but it comes straight from the guidance document from the governor. And it basically just says on a case-by-case basis, an agency can, with a written request, consider any faith-based organization that doesn't meet these criteria. Mr. Chairman, all I'm trying to do is make sure we don't have a black box for a faith-based organization when they want to try and compete. This is the system that worked well for the administration, and that's why I'm proposing it today with the best intention to not harm your bill, but to use the same language that the governor used. But, Mr. Chairman, I do have to tell you, accidentally, another proposed amendment that I had not had a chance to discuss with the patron is in here, and I'd like to sever that from this discussion. It's unless the committee wants me to include it, but it's lines 138 to 140. And this is language directly out of Senate Bill 868, that just basically talked about religious corporations, because in here is the part about schools and employment, and I think that's the other part of the testimony we heard last week that I didn't understand what it was relevant to, because I thought we were only talking about contracts.
Right.
But I think we were talking about that. So it's not my intent to do any harm, but to use language we've all already approved that comes from the administration and us to provide some clarity so that we're able to kind of build consensus here. And on with that, Mr. Chairman, I move these amendments.
I'd like to respond to the amendment if I could,
Okay,
Mr. Chairman.
right.
So I have.
Wait. Is there a second? Second. All right, we got a motion and a second to have this as a substitute.
Okay, so I have concerns about the amendment because, first of all, the amendment goes further than the guidance does, and I can go through that as well. But the other thing is that the guidance, to the extent it exists, works well with the current language of the code, which basically, with my bill, incorporates executive order already, so the code isn't changing. They can still do this guidance. The guidance refers to other laws and regulations, and it's there based on other laws. There are other laws, like a law that says that you can use taxpayer funds to discriminate in adoption agencies, for example, which is not part of this bill. It's a separate law. And so what we're doing is we're having a guidance that's referring to other laws outside this one, and now we're saying that this law is somehow part of other laws that aren't named in here. And I think it leads to real complications in the code. Furthermore, the guidance as it's written says that you can't discriminate and you can't include discrimination unless the state agency.
Mr. Chairman, I'm sorry, I don't mean to interrupt, but if you have a copy of the substitute and you're speaking to the substitute, can you speak to the line items and issue you might have with those line items? I think that would be informative to the committee to hear.
Certainly.
Versus picking apart different things. And
Certainly.
That would be very helpful.
The substitute basically is 239 to 257. And let's, and what I'm comparing it to is the guidance that I was provided that is a regulation that is based not on this law, but is based on other laws. And I think you can see that where it says in line 245 that based on consideration of other applicable laws or regulations, that they can put stuff in here, only they say it's different from the guidance because it says notwithstanding the provisions of subsection A, whereas the guidance is actually pursuant to the executive order. So what we find is that this is much greater and broader than the guidance. It doesn't, in fact, the guidance says you have to explain why you want it. Here it says for whom you want it. There's just a lot of distinctions here. I think we should leave regulations to the regulators. They've done this in the past. They can continue to do it. No one has argued that this bill does not allow this guidance. And that's really, really important. The bill allows this guidance. But to put a changed version of this guidance, and we can go line by line if you want, but where this is different from the guidance, to stick it in the code and frankly put stronger language in here and then refer to other laws that aren't mentioned strikes me as not the best way to do this. I think this guidance is currently allowed and will continue to be allowed.
Senator Donovan.
Thank you so much, Mr. Chairman. The language of the guidance document, which was framed exclusively for the executive order, was converted to remove paragraphs that reference the executive order to instead address paragraphs in here, A1 of the same section.
Right.
And I'd be happy to have council speak to that because they drafted it for us. And the language, I believe, is the same. But I'll let council.
If you like, I could go through where they're different.
Council?
Thank you, Mr. Chairman. Yeah, the language was drafted very closely to what I was given from the guidance document, except for changing the sections to reflect the sections in these two sections of code, and some reordering just to make it make sense. But otherwise, the language is fairly close.
And Delegate Levine, I did check with the Northam administration as to some of the issues that have been raised last week. And they did indicate that, at least a preliminary observation of theirs was that they felt that if we passed the bill as you had had it before us last week, that would override the executive order because of the guidance documents, and that they would no longer be in place. So that.
Well, Mr. Chairman, so first of all, the Attorney General has expressly said that, and I'll get the exact words so I don't misstate it. What they said. Excuse me here. That they support the bill, but in any case, I will get.
Mr. Chairman.
But
can I just,
yeah,
Mark, if I might interrupt for just a second. I like this bill. And I like all the places that you found discrimination in the, not like the place you found discrimination. I like that you're addressing it comprehensively in everything from auto insurance to apprenticeships agreements and everything else. It sounds like some members of the committee are concerned about the contracting piece, which I would like to resolve too. And I'm just wondering, I mean, you're getting, you're going to get some pushback on that. I don't know how much you want to push back, but I don't know if there's the appetite. I mean, we'd have to take a little poll here to do that without putting in the guidance. And personally, I'd rather avoid putting the guidance into the code, but I don't know if you got the votes for that, so just FYI.
There's another option, since the guidance is allowed in the executive order, and since I believe that all this bill does is codify the executive order, we can take out the contract provisions, and I think we'll be just where we are, and that's fine. We can pass the rest of the bill, because the executive order is, in effect, I mean, I would argue the executive order is what this contract provision is. I mean, we can go through why I think the guidance is not the same as what was put in this bill. If you want, we can go line by line. I can start with C. I mean, or maybe you could take a.
Try to move along here.
All right, no, I mean, that's
Chairman,
my
move right
problem
ahead,
with it.
Council, right.
So, where are we now? You're saying that you're okay with taking out the contracting provision? You want that in, or what's the?
I mean, I think all this does, by adding two words, sexual orientation, gender identity, is it codifies that executive order I just handed out for you. So that's all it does. And since the guidance is allowed in executive order, the guidance will be allowed today. If we add the guidance, then we're going to be changing the code to say that one section of the law has to allow other regulations, that's what it says in line 245, other regulations to change this law. And that's where it gets really hard, because regulations can refer to regulations, but have a law be determined by regulations, I think I just think it gets really messy there. And I can go through where it's different.
We don't need to go through bit by bit. I mean, we don't have that much time, so. And I don't want to be here till 1 a.m. again, so.
The
Senator
substitute's
McPike.
been adopted before the committee, as I understand it.
What's that?
There's a motion and a second, and the substitute was agreed to, correct?
No, the substitute's not been acted on, so we're discussing that because it's relevant here as to whether or not we would act on the bill as the patron has proposed it, or with possibly some amendments to that, or whether we would act upon the substitute that's being proposed here. So that's what we're debating right now, which of those two paths to go down as to what we would, the framework for what we would be considering here.
Mr. Chairman?
Yes, Senator Bell.
I would ask that we sever the different amendments, if we could, please, when we do make that
That was
vote.
my proposal, and I was going to say that too.
And I greatly
agree.
appreciate that. And then, Mr. Chairman, I guess the other question I've got, your specific concerns, I would like council to respond to that, because when you drafted this, I think, you were starting to explain that. We've got off track a little bit, but if we could go back to that, Mr. Chairman, where you can talk about the guidance documents and how you codified that.
Okay.
And these differences, because.
Yeah, counsel, can you help us out here, so?
Yeah, thank you, Mr. Chairman. Yeah, just to be clear, I did not have the guidance document myself, but I was given what I was told was the language from the guidance documents. But from that language, assuming that's the correct language, I have no reason to believe it's not. From that language, again, the major differences were changing. The guidance documents, I believe, referred to the general provisions that is a document, maybe with DGS, that discusses contracting for state agencies and directs them to put these contract provisions in. And it says in the guidance document, general provision, whatever, G1 should be put in, but not under these circumstances. So we just changed that to provision A1A here in the substitute. So that's one of the changes. The other thing is the organization of the guidance document. Thank you. The organization of the guidance document had what is subdivision or subparagraph rather C as below the first paragraph, below what is subsection D. So it would have said first, a contracting agency may make et cetera. And then after maintaining the procurement file, it would say any solicitation shall explicitly state, but that's just been reordered. But other than that, the language
So are
is
you,
the same.
Council, are you referring to the lines 239 through 257? Is that what you're in the substitute?
Yes, that's what
Okay.
that's what we're referring to.
So let's go where it's different, if we're going to go down that road. Here's what the
Well,
guidance says.
let's try to deal with sort of where we are overall on things.
It's not the same.
And I think there are basically it seems to me there's two major decisions that need to be made. Are we going to use the bill as it came from the House as the framework for this, or do we want to use the substitute that's been proposed by Senator Donovan on that? And then secondly, based upon the patron saying he would be happy to exclude the contracting portion of the bill, we would do that in either of those two. So within the committee, is there discussion about which of the two paths to go in terms of the proposal that would provide the framework?
Mr. Chairman, just to get us off the ball, I'll get the ball rolling one way. I would assume that Senator Donovan has moved or is going to move first, and I would second that.
Yeah,
we adopt the
that's
substitute.
been a motion and a second on that, but what I wanted to do was make sure that we discussed everything thoroughly so everybody was comfortable with which direction we might go out of those two.
Speak to that
Senator
proposal.
Donovan.
First of all, Mr. Chairman, I want to, in good faith, be clear that the amendments that I am proposing do not include lines 138 through 140.
Right.
The second thing is that I think there's a value in the code being consistent. And I think not including these two sections are going to result in us having this conversation next year. And that we're going to be talking about making sure the language of our code, one of the things we're doing here in this robust bill is that we're changing this throughout the code.
Right.
And I think there's merit to that consistency. And I think that the guidance document and the idea that you can, I think this is just good language that's been vetted. It's been used for all the years since the executive order went through. It's working. And I think it solves our problem for us in long term. So, Mr. Chairman, to that end, I think probably the best option is to proceed with this language.
All right. Is there further discussion among the committee on that issue?
Mr. Chair?
Yes, Senator
My
Hatchman.
concern is that the patron of the bill is not happy with the substitution. And if we are going to be addressing the issue, the bill that he has brought before us, I think we need to respect his observations and what he is proposing. Delegate, am I correct that you would reject the substitution?
I would urge the substitute be rejected, if only for many reasons, but if only because the current guidance is not identical. And I know we don't want to go on that road because it's complicated. But it's not identical. I understand the council has tried in good faith. The guidance says, in fact, that the executive branch will only contract with those who abide by the non-discrimination policies in the executive order. But that's not in the substitute. The substitute says, notwithstanding the non-discrimination provisions, we're going to do this. This guidance says we're not going to discriminate, but other laws and regulations, not mentioned in this bill, other laws and regulations allow discrimination to the extent that that happens. That's why this is a regulation. It takes account of lots of laws and regulations. What this is saying for the first time is we're going to make an exception to the executive order, and we're going to allow discrimination right here in the code. It takes this guidance, which refers to other laws and regulations, and makes it an exception when it's not an exception. In fact, the guidance specifically says that executive branch entities shall include this.
Mr. Chair?
Senator Boysko.
Early in the discussion, the patron said he would be willing to take out the contractor provision. That seems to be a cleaner solution to me, and keep his current language. He has expressed that he would prefer not to have the substitute. I'm trying to honor that
Mr. Chairman.
on his
Yes,
part.
Senator McPike.
So one of the things that I really value is actually having non-discrimination policy where we put our public dollars. And so if we have to figure out a way, and I think Senator Donovan has tried to address these things, I'd rather have it in and have a more robust vehicle that covers the issues within our contracting framework versus piecemealing. And I think there's a lot of good code sections that have been put in place. We've worked through this, and I think we are arguing around a tenet that has been in executive orders as well as in our law in terms of the ability for religious institutions to still procure and participate in contracts. However, there's certain code of conducts and other things that have been a part of court cases and other things, and I think that's what Senator Donovan tries to tackle here. There's still, Mr. Chairman, room through the process. If there's tweaks, the governor's office can also address some of those to make sure that we are consistent through this, but I think there's a number of different things that, frankly, I would like to see the contracting and procurement remain, because I think it's good public policy.
Mr. Chairman.
Senator Donovan.
I just want to read here, just for clarity, line 248E, the decision not to include subdivision A1, which is the exception, in a contract shall not indicate that any contractor or subcontractor is permitted to engage in discrimination, and that's clarified. So I just want to refute the point he made. It does not allow discrimination in any way, shape, or form.
Mr. Chairman.
Senator Bell.
I know you want to say something, but if you can give me just one sec. First, I think, I applaud Senator Donovan. I think she's done a lot of work on this to try to move this in the right direction, and I think her intentions are very honorable. My question, this to Mr. Chairman, is maybe to you. You were talking about conforming to the Senate version. My understanding is the House has a couple different versions. Is there anything to do with this? Is this the only vehicle? It stands alone? So the bottom line is, if this passes, then you have a chance to push it to a conference later, and then there's more time to work through this contracting language. So, I mean, Mr. Chairman, I know we probably want to hear for testimony, but I would prefer to vote on this severed amendment, and I guess my mind is thinking, let's push this through. I like having it in the code too. I think a lot of good work has been done here. And you still have a chance to work through your issues to get to the right answer. And I think we're going to have a much better end product if we have that in here.
All right. Any other discussion within the committee? All right, let's vote now on whether or not to adopt the substitute proposed by Senator Donovan, with the exception of lines 138 through 140. All in favor, say aye. Aye. All opposed, no. All right, that's what we'll work from there. Do you want to propose then lines 138 through 140 as an addition?
I would be curious to see how the patron feels about lines 138
I would prefer
through
that
140.
not be in there.
I think that's sufficiently in the code in Senator Evans' bill, and so I think we can move forward.
All right, well, we will not act on, there will not be a motion to adopt lines 133. No. Because what I said was that we were doing Senator Donovan's proposed substitute minus those three lines.
So I have just a point of clarification.
Sure.
The substitute, like the bill, is, the substitute's 90 pages long. The bill is 39 pages long. May I take Senator Donovan at her word? I just want to be very sure that the only changes, because there's a lot of code here, is 239 to 257, and I think you said there was another section that repeated this same language.
I am confident in our counsel that only those two changes were made in the two subsections where you addressed contracting. And so those are the only correct, thank you, line 372 to 390. And you also have my word, Delegate Levine, that if there are inadvertent languages, words in here that disrupt the language that was the intent of that guidance document, we'll be happy to talk about making changes. But I think this is really good for the Commonwealth, and it gives us a point of consensus going forward, and it makes our code aligned. And so I'm sorry this was disruptive for you, but I'm excited we got to this point because I think it's important.
Thank you, Senator Donovan.
All right, we now have a motion and a second to report. The bill is amended. Certainly, Senator Evan.
Just for 10 seconds, Mark, Delegate Levine, thank you for finding all these references in the code and cleaning it up. So just
How
want to
long
thank
did it take you?
I know it's been a few years' work.
A long time. I've been putting this bill in for 4 years. There are actually a ton of people who want to talk, but I think they could just raise their hand. Maybe just raise their hand if they support this bill. There's a number of people who.
Yeah.
All right.
Those who are in favor, raise your hand.
Stand up.
All right.
I just want to show that's all.
All right.
Thank you, Mr. Chairman.
Thank you. And is there anybody in opposition that wants to be recognized just by standing or raising your hand? All right. Thank you to all of you. All right, well, we now have a motion before us to report the bill in the nature of amendment in the nature of a substitute. If there's no further discussion, let's vote on the board.
Ayes 9, noes 3.
Thank you,
All
Mr.
right.
Chairman. I
Thank
do have
you
one
very
more bill that I hope is a lot simpler than that one.
We do too.
It's House Bill 321. This is a bill about allowing local officials, like those that sit on city council and county boards, to attend meetings electronically. Now, under current law, if a member is unable to attend a meeting due to a personal matter and identifies it with specificity, then twice in a year, they can choose to attend electronically. Actually, it's not quite a choice because the city council has to approve that. Actually, the Vice Mayor of Alexandria, Elizabeth Bennett Parker, brought this bill to me because if you meet 4 times a year, 2 meetings, that's a lot of meetings to only attend electronically. That's half of them. But if you're like the City Council of Alexandria that meets 50 times a year, 2 out of 50 is not that many. So this bill allows 2 or 10%, whichever is greater. If they meet biweekly, they could miss 3 times in a year. They're not really missing, they're attending electronically. It also allows a member to attend the meeting due to the serious medical condition of an immediate family member that prevents the member's physical attendance. They can attend by electronic communication. Vice Mayor Bennett Parker was attending her very sick parent in Florida and found that because of the current law, she couldn't participate. I know that VML and VACO support this bill. I think they're here, if they're still here, and that's the bill.
All right. Has this issue been vetted through the FOIA Council or anybody like that?
No, this came to me from the Vice Mayor, and I do know that VML and VACO support this bill.
All right. Are there questions of the patron on this issue? All right. Those in favor, please come forward and speak.
Just raise your hand.
Thank you, Mr. Chair. Phyllis Arico from the Virginia Association of Counties. We think this gives our elected officials a little more flexibility to do their elected job and also take care of their family. We support this bill.
All right.
Michelle Gowdy, Virginia Municipal League. We support the bill for the same reasons. Thank you.
All right. Anyone else in favor, or next, we'll have those who are opposed, so.
Thank you, Mr. Chairman, members of the committee. I'm Megan Ryan. I'm with the Coalition for Open Government. And as Delegate Levine mentioned upon your question, and as Senator Lott can tell you as chair of the FOIA Council, and as Senator Stewart could have told you if he was here, he's the chair of the FOIA Council. This did come to the FOIA Council in December, and the council did not act on it. So it has not been studied by the council. If it had, I think a couple of the things that would have come up were, 1, this is already covered by existing language by a personal matter. 2, this new category of serious medical condition that prevents the member's attendance is unlimited. So we're both increasing the number of times you can do it in lines 21 to 22, and you're adding a new category that has no limits on it whatsoever in terms of as many times as you can use it. And then also, I think what would come up is that it does lend itself to the opportunity for invasive questions and or manipulation by the elected member as to what actually constitutes a serious medical condition and whether or not that condition actually prevents the person from attending. Those are 2 specific questions that they would need to address. Finally, with respect to lines 21 to 22, where the number of times is being increased, yes, it is 2 times for a board that meets maybe 50 times. That might not seem like much. But if we go with 10% or the next higher number, we're going up to 5 or 6. That's a 3-fold jump without having been studied by the FOIA Council that has a standing committee on electronic meetings. So we would ask you to not support this bill. Thank you.
Very briefly, Mr. Chairman.
Senator Locke, do you have any observations since you're on the FOIA Council?
I mean, I think that this is something that the FOIA Council needs to continue to look at.
at this time, because we didn't have any time to really fully examine this particular issue about electronic meetings.
Okay.
So, Mr. Chair,
Delegate Levine.
briefly, there is an easy way to police this, and that is the local government has to approve each and every time it happens. So if someone is abusing it, they simply say no. And the other thing is it's the serious medical condition of an immediate family member that prevents the member's physical attendance. So it really requires someone out of state, serious medical condition, even a serious medical condition of an immediate family member where they're in town would not prevent their physical attendance. I think it's a very small carve-out, and it's one, as you can see, that local officials want. And again, if you allow 2 meetings in a year to quarterly meetings, that may even be too much. But to not allow 3 when you have 50 meetings a year strikes me as far too little. So I think it's a very reasonable, modest proposal that our local officials want. And they're still participating in the meetings, to be clear. They're not missing. They're participating electronically.
Are there other questions of the patron or anyone else?
Mr. Chairman, I think that this is the proposal that needs to go before the council. This was not the proposal.
What now?
I think this is the proposal that needs to go before the council to examine.
Okay. You want to make a motion?
I move that this HB 321 be referred to the FOIA council.
All right. And you would?
With a letter. I move that House Bill 321 be passed by indefinitely with a letter to the FOIA council.
All right. Is there a second? All right.
Substitute motion that it be
All right.
continued and referred to the FOIA? Okay.
Yeah. Well, if you continue, it won't be a letter, but, we can handle it either way, to tell you the truth. All right, there's a motion to pass it by indefinitely with a letter to the FOIA council to have them to work on this over the year and hopefully come back with a recommendation for next year then. Is there any further discussion on the motion? All right.
Just say this has broad support among local officials, and it did pass 97-2 out of the House. But
That's right. All right.
Speaking of that motion, I have a great deal of respect for what Senator Locke has done with the FOIA Council in the last few years.
Right.
And I certainly mean no disrespect to Senator Locke in any way, shape, or form, ever.
You better not.
I never would. I never would.
All right, we have a motion to pass it by indefinitely with a letter to the FOIA council to have them work on this over the year. If there's no further discussion, we will vote on the board.
Thank you, Mr. Chair, and members of the committee.
Thank you very much. We'll see you around, so. All right, next we have Delegate Bourne.
Thank you, Mr. Chairman, members of the committee. House Bill 1420 places a cap on late fees that a landlord is able to charge a tenant, to caps it at 10%. In addition, we also put in some protections in there so that the late fees cannot cascade and be tacked on to late fees upon late fees upon late fees.
Right.
This is the culmination of a work with a lot of stakeholders who really worked tirelessly, and I thank them for their efforts on this. I think this will go a long way to helping us address our eviction crisis here in Virginia.
All right.
I'd be happy to answer any questions.
Quick comment and question. I've gathered from things that have been said to me that there's sort of a variety of stakeholders from different perspectives that have come together and been able to negotiate on this.
Mr. Chairman, I will
Our
tell you,
broader
everyone
support.
from the Realtors Association to the Apartment Owners Associations to the Poverty Law Center to the administration, it's a broad cross-section of stakeholders that really came together to get us to where we are now.
So you're applying for the job as a miracle worker here? Is that what-
No, sir. No, sir.
Mr. Chairman, may I thank the patron for him representing all of his advocates?
Yeah, that's right, that's right. All right, is there any questions of the patron here? All right, anybody in the public want to voice your support for this?
We know there's.
Just do it quickly.
Administration supports, sir.
All right.
We got you.
Yep. Poverty Law Center
Poverty Law
supports.
Center.
Apartment owners.
All right. Apartment people.
Mr. Chairman, with that, could we move
Yes.
to report?
Yes. We have a motion and a second to report the bill, and this is not one that has to go to finance, so we're good there. So we'll have a motion and a second. We have a motion and a second here. Any further discussion among the committee? All right, vote on the board.
Ayes 11, noes 1.
All right, ayes 11, noes 1.
Mr. Chairman, I thank you and the committee members for your time.
Certainly. All right, next we have Delegate Guzman.
Thank you, Mr. Chairman, members of the committee. I have an amendment in the nature of a substitute.
Second.
All right, it's been moved and seconded that the substitute be adopted. All in favor, say aye. Aye. All opposed, no. All right, the substitute is before us now.
Thank you, Mr. Chairman. Last week, I presented the bill, and Senator Donovan, what I would like to thank her, brought up a concern about not being discrimination with cultural competence in general. So I tasked myself to speak to the Department of Human Resources. I spoke with different organizations in government, and I learned that we actually do not have cultural competence in general. So for that reason, I have presented this substitute, and this substitute is talking about cultural competence and to complete an online diversity and cultural competency training model provided by the Department of Human Resources within the 90 days of commencing employment or recommencing, and each state agency shall maintain records showing that each employee has completed the training required by this section. And it will be that such a training model shall include information relating to race, ethnicity, disabilities, gender, religion, and other protected classes under the state law, Mr. Chair.
All right,
And it has to go to fine.
Yes, it does. Yeah, are there questions of the patron?
Comment, Mr. Chairman?
Yes, Senator Donovan.
Delegate Guzman was so kind as to send me a copy of this because we had talked about it in committee. I think it's a really good bill, and I'm glad that we figured out that we needed all this. Is what we do in medicine. This is great.
Right. All right, any other questions of the patron? Anybody wish to speak in favor of the bill? Anybody wish to speak in opposition? All right. And move to report and re-refer to finance. So a motion and a second to report and re-refer to finance. Any further discussion on the committee? All right, vote on the board.
Ayes 10, noes 2.
All right, ayes 10, noes 2. The
Thank
bill
you.
is reported and re-referred to finance.
Thank you, Mr. Chairman. One more time, thank you, Senator
Monday
Donovan.
we'll see you in finance.
All right, you'll see you then. Thank you.
All right. All right, thank you very much. Next, we have Delegate Plum.
Thank you, Mr. Chairman and members of the committee. I have House Bill 1354.
All right.
Chairman and members of the committee, I could go on at length talking about the challenges in our environment
Please don't.
No, I was leading up to say I won't unless you insist.
Okay.
But nonetheless, the challenges that we face related to plastics are before us. And as I thought about how we might approach this in this legislative session, I realized that the options were not necessarily particularly good ones. Now, what we needed to do is to develop a collaborative approach with industries that are affected as to how we might work together to turn, notice I've changed the name with the suggestion of industry from plastic pollution to plastic waste, meaning that plastics then serve as a commodity. And the example I'll use is that of Trex lumber. You know, if you take plastic grocery bags and some sawdust and cook them together, you make Trex lumber. So that is turning what is a waste product into a beneficial product. What's proposed here is that we form a collaborative group with industry to look at what other options might be to resolve issues of how to deal with plastic problems. Now, I think you have an amendment, correct? And the amendment was brought to me by industry folks who wanted to like the idea so much that they want to get involved as well. So what we'd have would be some legislative folks and some people from industry looking at what our options might be. On the one hand, we might solve our pollution problem our waste problem, but on the other hand, we might in fact develop meaningful industries that would deal with this challenge. So you have an amendment.
Council.
Thank you, Mr. Chairman. After line 70 of the engrossed bill, insert 2, that the Plastic Waste Prevention Advisory Council shall submit to the governor and the chairs of the House Committee on Agriculture, Chesapeake, and Natural Resources, and the Senate Committee on Agriculture, Conservation, and Natural Resources an initial report that provides recommendations on legislation to accelerate the elimination of plastic bags and polystyrene packaging used or sold in the Commonwealth no later than November 1st, 2020.
And again, Mr. Chairman, the intent is not to conflict with the bills. And I know Senator Edmonds and others have done a lot of work on this. I don't mean to conflict with that. I simply mean to build on the work that they've made. Looking forward, what else can we do?
Mr. Chairman, I would move that.
All right, we got, all right, motion is made and second to adopt the amendment. Is there any discussion?
One question.
Okay, yes.
Is that report you're referring to also going to the chairman of the Commerce and Labor Committee?
I think it's drawn to the.
It's in here? Okay. Oh, ag.
Ag.
Yeah, I was
Ag.
just wondering if you'd also want it to them. But I think it's a great bill because of not just tracks, but other things that you might be able to do.
Yeah, I'm going to get one of the copies of the report, and I'd be happy to make another copy and give it to somebody else you want.
I think that's great.
All right, any further discussion?
Mr. Chairman?
Yes.
I think it's great that General Laws gets to assign work to the chairman of agriculture. This is fantastic. Should, Mr. Chairman, follow up serious question, should it be or designee or appointee of the chairman? I'm just throwing it out there. As written, it says it's the chairman of both of those committees, the House and the Senate, correct?
Yeah, I think that's sort of the standard thing, to send them to the chairs of the committee.
Yeah, I have no problem with that, however you choose to do that.
Yeah. All right.
Mr. Chairman?
Yes.
I'm deeply concerned about the significant fiscal impact. It's $1,200, but does it have to go to finance?
No.
Okay, good.
Yeah, we passed on that one, so, did we adopt the amendment?
We adopted it.
All right, we're good there on the amendment, all right.
So, Mr. Chairman, to allow
Yes.
some flexibility, could council maybe advise on my proposed or designee or appointed by the chairman of Ag on the House and the Senate?
Thank you, Mr. Chairman. Yeah, this is standard language, so I don't see why, if there was a designee, they couldn't just say, hey, give it to this
Okay.
guy. But, we can add that in if you'd like.
So, follow up, Mr. Chairman?
Yes, Senator
To council.
McPike.
So it's implied already as written by the language? If so, I'm fine with it.
Yeah, I have no problem either way.
Mr. Chairman, I understand what you're trying to accomplish, but
Right.
the standard language is the chairman.
Right.
And when it goes to finance, it goes to the staff.
Mr. Chairman, follow up. It's not about the report. It is about the membership of the committee. And so we're assigning the chairman of Senate Ag
Oh,
to a
okay,
commission,
okay.
to this commission. So that's my only point, is we are assigning, which is fantastic, by the way, we get to assign work to another chairman. I love it. But having said that, I may want to give some flexibility. And so the question to council is, as written, does this give the chairman the flexibility to appoint someone, or is they are on the committee?
All right, so this is under section B, is that correct? Yeah. They should be appointed,
Sorry, Senator Ms. McPike. Could you repeat your concern one more time, just so I'm clear?
So section B, we are appointing the chairman of House Ag and Senate Ag
right.
to the committee. Does the language provide any flexibility for them or them to designate a member of the committee to serve in that role? Should they have 1,000 other assignments or something else going on? Not that this wouldn't be the focus of their attention. However, in the future, maybe there's some flexibility that could be amended.
Thank you, Mr. Chairman. So you're referring, Senator Pike, you're referring to the text of the bill, not necessarily just the amendment, correct?
That's correct. This is the text of the bill.
Okay,
On
yeah,
lines
so-
20, 23, and 24.
Okay. Yeah, in that case, we should probably add or designate. I'm sorry, I thought you meant the amendment. My
No,
fault.
Thank you for
All right,
clarifying. Yes, it's the bill itself, so.
All right, you want to make a motion to
I
add
move
or
the amendment.
designate in those two situations? All right, it's been moved and seconded to have the chairs or designees made by the designee of the chair. All in favor, say aye. Aye. All opposed, no. All right, that amendment's adopted then, so thank you. Finally figured out what you were talking about, so that's all right. All right. All right, is anybody opposed to this bill? All right, we have a motion and a second to report the bill as amended with a couple of minor amendments here. Any discussion among the committee? All right, let's vote on the board.
Ayes 12, no zero.
All right, the bill is reported.
Thank you very much, Mr. Chairman and members of the committee.
Yeah. All right, next is Delegate Hurst.
Thank you, Mr. Chairman, members of the committee. I believe that council has a substitute for you.
All right, it's been moved and seconded that the substitute be adopted. All in favor say aye. Aye. All opposed, no. All right, the substitute is now what we're acting on. So,
All right. Thank you, Mr. Chairman.
Give your presentation. Sir.
Mr. Chairman, members of the committee, the substitute hopefully will take away some of the anxiety that you may have been confronted with by a lot of stakeholders on this bill as it came over from the House. What this bill does now is it directs the Division of Human Rights with OAG to develop recommendations regarding the type of information about businesses, employees, and methodology would be required if the division were to proactively enforce provisions of 4128.6, which is making sure that people get paid the same irrespective of sex. In developing such recommendations, the division shall engage stakeholders representing employers and employees in the Commonwealth, and there will be a report of findings. This substitute comes to you having worked with many different stakeholder groups, including some of our telecommunications friends, and we also were in discussions with the Chamber of Commerce who helped us get this language to where it is now. So basically, we want to start the process of finally addressing how we enforce the fair pay laws that we have on the books in Virginia. The EEOC collects some limited information, and the future of how much information is going to be collected is really up in the air and is dependent upon whomever is in the White House any given year. I think it's really important for Virginia to try and carve out a status as being a leader in trying to close the gender pay gap in the Commonwealth. And this would at least start that conversation to see if the Division of Human Rights can come up with what the criteria would be for information that we would be requesting, and then what the actual enforcement or abilities might be for an individual who feels like they were discriminated against and they were wronged and had the law broken against them because they weren't paid the same just because of their sex. Or race is also something that we wanted to address too, and so you see that in line 14 as well.
All right, are there any questions of the patron? All right, is there anyone who wishes to speak in favor of this? Anyone to speak in opposition?
Mr. Chairman, I just want to say thank you to the patron. I know he spoke with me about this. A lot of hard work went into this. I think this is a much wiser, more prudent approach. And with that, I move to report.
And this needs to go to finance, so you'll need to add a little extra there too.
Mr. Chairman, substitute needs to go to finance?
It is listed here as needing to go to finance.
Mr. Chairman, the only thing I will say, and obviously if you have a letter, you have a letter, but we did talk to OAG and they said that it has eliminated the fiscal impact. And I already have talked to House Appropriations staff because it was included in the House budget that OAG has now indicated that it is not in the budget, is no longer fiscally necessary.
Well, I have a letter dated I have a
Yes,
letter.
yes. So all of that to say, I will be happy to go to finance too.
I'm
so.
sure you want to come back up again, so.
Yes,
And I
yes.
do have a letter that was dated yesterday, so it's, so
I will see those
All
of
right.
you in finance, and I
Monday.
look forward to it.
but we'll have our meeting on Monday.
I'll be there. Thank
All
you.
right, so we have a motion to report and re-refer to finance. Any discussion on that? Okay, we'll vote on the board.
Ayes 9, no zero, abstentions 3.
All right, it's reported and re-referred to finance. All right, next we have Delegate Jenkins.
Mr. Chairman, members of the committee, good evening.
Good evening.
HB 1505 is an agency bill. Is a vehicle whereby the Department of Small Business can do more on utilizing the same resources by moving the cash balances from the Small Business Job Grant Fund to the Small Business Investment Grant Fund. It also seeks to reduce the amount of grants to the participants from 50% to 25%, allowing them to serve more participants. And that's what this bill does.
All right, any discussion, any questions of the patron? All right, so no questions of the patron. Is there anybody wish to speak in favor of the bill? Anybody wish to speak in opposition to the bill?
Move the report.
All right, we have a motion to report and a second to that motion. Any discussion among the committee? All right, vote on the board.
Ayes 12, no zero.
Thank you all.
12-0,
Enjoy your
you're on the uncontested calendar, so. All right, Delegate Krizek.
Thank you, Mr. Chairman.
Yes.
HB 1646 is an administration bill. Comes at the recommendation of the Interagency Task Force on Misclassification and Payroll Fraud. And what it does is it requires contractors to appropriately classify all workers as either employees or independent contractors. And I have the director of DPOR here.
All right, are there questions of the patron? All right, anybody wish to speak in favor of the bill? Anybody wish to speak in opposition? We got a thumbs up over there, so, all right, we got a motion and a second to report the bill. Any further discussion in the committee? All right, let's vote on the board.
Ayes 11, no zero, 1 abstention.
Thank you,
All right,
Mr. Chairman. Thank
the
you,
bill is
committee.
reported, so. Thank you. All right, next is Delegate Hudson.
Mr. Chairman, just an observation. Based on the number of abstentions, I'm glad your voice is recovering for your floor presentations.
Yes, I do. I don't need to repeat last Monday, next Monday, so. Yes,
Thank you, Mr. Chairman,
certainly.
members of the committee. House Bill 1106 would lower the cost of health insurance for bus drivers in Central Virginia. It was developed in collaboration with the Jefferson Area United Transit Company, otherwise known as JAUNT. JAUNT is a public service corporation that serves 6 localities in Central Virginia. You'll notice that the bill is co-patroned by 6 bipartisan delegates who serve that region. JAUNT is jointly owned by the localities that it serves, but its employees aren't direct employees of any one local government. So they're currently ineligible to purchase health insurance through the local choice program. So as a regional public service corporation, they're sort of falling through the gap between local and state public health insurance. This bill would solve that problem by making JAUNT eligible to participate in local choice. They're not the first regional quasi-public service to have this problem. There's a section of the state code that lists other similar services like library boards and social services boards, welfare boards that are allowed to participate in local choice. So this bill would simply add transit companies to that list as well.
All right, are there questions of the patron? All right, is there anyone who wishes to speak in favor of the bill? Anyone who wishes to speak in opposition to the bill? Bill is before us. All right, we have a motion and a second. Any further discussion? We will vote on the board.
Ayes 12, no zero.
All right,
Thank you,
ayes
Mr. Chairman.
0, the bill is reported. All right, next is Delegate Hayes. You moved down the road there for,
Yeah. Thank you so much, Mr. Chairman, members of the committee.
yes.
Should have in front of you House Bill 1082.
Right. All right, go ahead.
Okay, Mr. Chairman, members of the committee, what this bill will do is define cyber incident for the purposes of the Emergency Services and Disaster Law as an event occurring on or conducted through a computer network that actually or imminently jeopardizes the integrity, confidentiality, or availability of computers, information, or communication systems or networks, physical or virtual infrastructure controlled by computers or information systems, et cetera. What we're getting at, Mr. Chairman, members of the committee, is trying to make it so that the governor, whomever that might be, would have the authority under code to declare a state of emergency in the case of a cyber incident. And so what we're told is that we have to define what a cyber incident actually is. And so that's what we're doing here with this bill.
Okay, good. Any questions of the patron?
Mr. Chairman, I do not want to slow this bus, but I am just curious how you came up with the definition.
I'm sorry, my hearing.
Oh, I'm so sorry, Delegate Hayes. How'd you come up with the definition?
The staff actually came up with the actual definition of it.
All right, yeah, yes. All right, any further questions of the patron? Anybody wish to speak in favor of this bill? Anyone wish to speak in opposition? All right, we got a motion to report and a second. Any further discussion on the committee? All right, we'll cast votes on the board.
Ayes 12, no zero.
Ayes 12, no zero.
Thank you, Mr. Chairman, members of the committee.
Bills are reported. Thank you. All right, next is Delegate Corey.
Good evening, Mr. Chairman, members of the committee. I have a bill that came to me at the request of the Fairfax County Housing Commission. They deal with redevelopment and low-income housing. They're also charged with floating bond issues to pay for Fairfax County's low-income housing purchases and maintenance. The bill changes the code, which has not been changed since 1987, about the amount of money that the members of the authority are allowed to be reimbursed as a stipend. In 1987, it's in the code that the stipend could not exceed $150. We are now suggesting that it be changed to not exceeding $500. One of the main problems with the old number is that it's a requirement, a federal requirement, that at least one, if not two people on the board have to be living in the low-income housing. So it's a real disadvantage for them not to be able to have their expenses reimbursed. That is the bill, Mr. Chairman.
All right, are there questions of the patron? All right.
Don't.
Is there anyone in the public who wants to speak in favor of the bill?
The presentation was longer than reading the bill, so I'm good.
All right. Anyone in opposition to the bill out there? Okay. We have a motion and a second to report the bill. Any further discussion in the committee? All in favor say aye. Or vote on the board. So, sorry.
Ayes 10, noes 1.
All right, ayes 10, no 1, the bill is reported.
Thank you very much.
Thank you very much. All right, Delegate Sickles.
Good evening, good friends, and Mr. Chairman.
Thank you.
And it's only 8 o'clock, so we got 4 or 5 hours to go tonight.
We got 5 hours to go.
Yeah, I'm still kind of trying to recover from last night, but I am back again with a bill you've heard before, HB 1663. Is it amended at this point? Okay, there are amendments to the bill that make it equivalent to the bill that the Senate Bill 868.
Right.
And as,
All right.
Yeah, this will be the exact same bill as what.
yep. We will, Mr. Chairman, we will, if you pass this substitute, we will avoid having to go to conference, and we'll send a second bill to the governor's desk. The first one's already over there. I'm sorry it couldn't have been mine first, but congratulations, Senator Evan.
All right. All right. All right, we got a motion and a second to adopt the substitute. Any discussion or questions? All in favor say aye. Aye. All opposed, no. The substitute's what's before us now. And.
Well, do you need an explanation again of the meeting? Okay, I don't.
Yes.
Okay.
All right. All right, is there anyone in the public who wishes to be recognized as supportive of this? All right, just stand up, yeah. All right. Thank you. You can sit back down now. All right, is there anyone in opposition? So, all right. Thank you. All right. Okay, this goes to the committee now for action. All right, we have a motion and a second, and it will need to go to finance, so you can amend your motion to finance. Yeah, and re-refer to finance. So is there further discussion among the committee? All right, we'll vote on the motion to report and re-refer to finance.
Ayes 9, noes 2.
Thank you, Mr. Chairman, members of the committee.
All right.
We'll see you upstairs too.
Yes.
Okay, thank you so much.
All right, thank you. All right. All right. The only other person.
Mr. Chairman?
Yes.
I have Torian's House Bill 1249.
All right. Delegate Torian, could you present your bill now?
Thank you. So, Mr. Chairman, House Bill 1249 has to do with the Manufactured Home Rental Act. This comes out of work over the last couple of years to try to deal with the situation where the underlying land of a mobile home park is being sold. So this sets out a provision to provide a 180-day written notice to terminate the rental agreement. Additionally, where the bill requires an owner who puts up a park for sale to provide written notice, including the asking price to the park tenants and to the Department of Housing and Community Development at least 90 days prior to accepting the offer. So it provides some provisions where a community could theoretically aggregate to purchase the mobile home park.
Okay.
As an example, that's what we did in East End Mobile Home Park in Manassas. Additionally,
I recall that, yes.
if the owners receive an unsolicited offer, it triggers a 90-day just notice of there's a sale coming. And so I understand that Delegate Torian has worked with the stakeholders to come to a level of compromise and understanding, and would rely on those here to be able to speak to it. Mr. Chairman.
All right.
Mr. Chairman.
Yes.
Delegate Torian,
Senator Ruff.
is this in conflict with the one we passed before?
No, not at all.
No.
Okay.
Yeah, there's some different provisions we worked on. This was a bill similar to a bill I presented that did not pass, I believe, 2 years ago, 1 year ago, I lose track. This is a more narrowed provision from where that started out with.
Chairman. Oh, excuse me.
Christine, were you going to speak on this one?
Yes, thank you, if now's the
Mr.
proper
Chairman, while
time.
he's talking.
Thank you.
It does not step on the toes of the other bill. That's essentially what I'm asking.
Mr. Chairman, Christy Meredith, the Virginia Poverty Law Center. Senator Ruff, no, it does not at all. The other bill deals with paying a portion of moving expenses for those few mobile homeowners who can actually move their home when a park is being closed due to sale to a developer. So that deals with what happens after the sale. This bill deals with what happens before the sale, so that as soon as a park owner puts a mobile home park up for sale, he would also provide 90 days notice, written notice, to every resident of that mobile home community, as well as to the Department of Housing and Community Development, so that they could post it online. And the underlying thing this is trying to get at
is something we see all the time, those of us who represent mobile home residents, and that is sales of these mobile home communities sort of behind closed doors, where the residents don't even find out that the park has been sold until they get a new written lease from a new owner or a 180-day notice from a new owner saying that they have to move out. So we think this is a really important step. And the two, I know that there were a couple of different numbers that Senator McPike put out there, but essentially what the bill does is it requires 90 days notice of a sale that is advertised, and then it requires 60 days notice where the mobile home park owner gets an unsolicited offer to purchase the park. That offer, it can be accepted contingent on the mobile home park owner providing that 60-day notice and also being able to and willing to accept alternative offers. He doesn't have to accept them, but he does have to consider alternative offers from an organization that represents at least 25% of the residents or from the residents themselves. Done.
Yeah, and I think we have folks that Delegate Torian has also collaborated with, and I understand there's concurrence and
Mr.
agreement.
Chairman, Randy Grumbine with I got to raise this up a little bit now. Virginia Manufacturing Modular Housing Association. We did work with Delegate Torian and other stakeholders, and we're comfortable with the language we reached. Thank you.
Mr. Chairman, members of the committee, Tyler Craddock on behalf of Manufactured Housing Communities of Virginia. We do appreciate the opportunity to work with Chairman Torian, and we know we've worked several years with Senator McPike as well, and we're fine with the bill. Thank you.
I'm not sure there's any opposition.
Sorry, Mr. Chairman, just to clarify, this is the exact same bill that we passed before, the 2535. I'm so sorry. Okay, all right, I'm going to abstain.
All right, we have a motion and a second to report. Any further discussion among the committee? All right, we will vote on the board.
Ayes 10, no 0, 1 abstention.
Delegate Torian, you did such a good job, so. All right, we are done for the year. Certainly, so. Yes. Yes.
Hi, Mr. Chairman. My name is Ann Creasy. I'm just here representing myself. I was not able to speak on House Bill 1663. I wasn't given the opportunity. I wasn't here in any other committee.
Yeah. I mean, it was an identical bill to one we'd already passed and acted on, the Senator Evans bill. There was the Senate version of that. And we'd had significant testimony on it then. So
I understand.
Thank you.